hold that notices issued to the petition to the respondent shall be deemed to be duly served. This civil revision is therefore directed to proceed ex parte against the sole respondent. Let this matter be listed for admission hearing after 2 weeks.
My lord. And there is an interim, my lord.
The interim order shall continue. till-
For orders, item number 14.
May I please, your lordship? Lordship, the return service upon respondent number 2 is still awaited. So if your lordship may kindly list a matter after 3 weeks.
Heard, Miss, what is your name?
Angam Kunyang.
Right. What is your name? Repeat your name.
Angam Kunyang.
Angyam Konyak. Learned counsel for the petitioner also heard Mr. K. Angami.
No,
N-
N. Angami,
N-
your lordship, for respondent number 1.
appearing for respondent number 1. Learned counsel for the petitioner has submitted that the notice is issued to the service report in respect of the notices issued to respondent number 2 is still awaited. And therefore, she prays for listing this case after 2 weeks. Stop. The prayer is allowed. Await further for the service report of notices issued on respondent number 2. List this matter after 2 weeks.
Thank you,
Obliged.
lordship.
Item number 15.
None has appeared for the petitioner on call. Heard Miss S. Mary Leonard, public prosecutor. List this matter after a week on a date to be fixed by registry.
Item number 18.
May I please, lordship, my lord, I am for the petitioner. It appears from the record that notice is not completed.
What is to be done? Will you take fresh steps or
But-
should we await?
If lordship permits me to take Dusty, because he is in service and notice still delayed.
Okay. Heard Mr. A. Zo, learned counsel for the petitioner. It appears from the office note dated 16/1/2025 that the notices issued to respondent number 5 has not yet returned. Stop. Await further. Stop. Next parent. Learned counsel for the petitioner also prays for allowing the petitioner to take steps for issuance of notice on respondent number 5 through Dusty mode. The prayer is allowed. The petitioner shall take steps for issuance of notice through Dusty mode within 7 days from the date of this order, returnable on 22nd of April.
Madam.
After serving the notice through Dusty mode, the petitioner shall submit an affidavit of compliance.
Madam.
List accordingly.
From the supplementary cost list for hearing, item number 33.
Who is for the petitioner?
Madam, lordship, he is there.
He's there, but
He'll
he's
come.
not visible.
But somehow he is, I
Your
think,
Lordship, he is in the
He's,
premises.
he's coming.
Yes.
Okay. Let him come.
Lordship.
Call another item. We'll take it up after some time.
Yes, Your Lordship.
Understood. Okay.
For motion, item numbers 36 and 37.
Public prosecutor would be required.
Yes. Lordship, this is a purely civil matter in which a money lending issue, Lordship. In 2021, on
This is item number
the
36.
Yes,
Yes,
my lord.
yes. What
in
is-
2021, the applicant, she took a loan of 2 lakhs rupees at Lordship an exorbitant rate of 10% per month, which accrues to 120% per annum. In Nagaland, we have an act, Money Lenders Act, under which unregistered money lending is a criminal offense, and lending money above the bank rate, 3% above the bank rate is also made illegal under that act, Lordship.
Okay.
But despite that, the transaction took place, it's all right, Lordship.
You took loan.
Yes, I took the loan, Lordship. Yes, I borrowed from the FIR informant, Lordship. I have given the name Stella, one Stella Pin.
Then
Now, thereafter, due to financial constraints, Lordship, the interest was 20,000 per month, Lordship, since the loan was at 10% per month, Lordship. So for 3 months, I was able to pay the interest. That is 1 month by myself and 2 months by the guarantor.
okay.
The guarantor is my younger sister. But due to financial constraints, Lordship, I was a primary school teacher at that point of time. I have also retired now, Lordship, and due to family financial problems, Lordship, I was unable to pay the amount. And last year, Lordship, a legal notice was served to me, Lordship, through the counsel of the lender. That I have also annexed in my IA anticipatory bail application, Lordship, at page 12, annexure P. This is the legal notice. Now, under this legal notice, Lordship, a demand of 8,20,000 was made, which I was in no position to pay, Lordship. From a loan of 2 lakhs rupees, Lordship, out of which I have already paid 60,000 as interest, Lordship. Another 8,20,000 was directed to be paid, was claimed to be paid, Lordship. So
Then
I could not make any payment, Lordship. Now, after that, Lordship, a FIR against me was filed at North Police Station, Kohima.
where is the affair?
I have also mentioned that, Lordship. I have made my best efforts to get a copy of the FIR, Lordship. The police, they are refusing to hand over. I have
Where is the case reference?
the case reference, the PR bond that I have signed, Lordship, because I was summoned by the IO. The IO telephonically called me on 6th of March, Lordship. And I went to the police station on 13th, along with the calendar. On 13th, we were threatened with imprisonment. And then we were made to execute PR bond, Lordship. And after much request, Lordship, the
PR bond means you are allowed to go on bail.
yes, Lordship, for a few days, Lordship. For a few days. So a list of items were given, Lordship, which I have annexed at page 15, the type copies at page 16, Lordship. This is a handwritten list, Lordship, written by the IO in her own handwriting.
No, what is the police station case? In which case you are?
Yes,
appealing
Lordship, that
against?
is what, Lordship, we have made every possible efforts, Lordship, in order to get
Whether
the
any FIR has been registered?
Lordship, that if the FIR has not been registered, Lordship, Lordship, or if there is no GT entry, then Lordship, PR bond shall not be executed, Lordship, in the police station, Lordship. We were directed to bring-
Under what provision the
Yes,
FIR
Lordship.
was registered?
Yes,
What is the
Lordship.
offense? What is the
Lordship,
offense
this
alleged?
is the issue, Lordship. See, Lordship, this is not a criminal offense. This is a purely civil issue, Lordship. There are a plethora of cases in which the Honorable High Court, this Honorable High Court as well as, yes,
That aspect is okay.
yes, Lordship, yes.
But
Now,
in which
the-
case you are apprehending arrest?
This case, Lordship,
Which case?
that is what, Lordship. The police, they are refusing to give me the FIR, the GTE number, the FIR number, Lordship, the police station case number, Lordship. All, and under what provision of law I have been, Lordship, booked. The FIR has been registered.
But you went to police station
Yes, Lordship. On 13th,
after being summoned by police.
yes, Lordship. Now,
You
that
have-
also only telephonically. Which is why, Lordship, I have mentioned that there is an abuse of
So
process of law.
you don't have any document.
No, Lordship. No document, Lordship. And Lordship, I was also made to execute PR bond on 13th. That also I requested to the police to be
Which police station?
not police station, Lordship.
North means not Kohima.
Yes, not Kohima, not police station.
Yes, Mr. Tibafo. You find out from the OC
My lord,
whether any case has been registered. We'll take up this matter at 2 again. Before 2, you find out from the OC telephonically.
Or Lordship, if a direction can be given, Lordship, not to take any coercive actions, and if
No, if suppose no case is pending,
Lordship,
then your remedy is elsewhere. Suppose a criminal case is pending,
yes, Lordship,
then we may grant you anticipatory bail,
Lordship.
considering the,
Or Lordship, or a direction may be given not to take any coercive action against me, Lordship.
in which case? Suppose you commit some other offense.
Yes, Lordship. No, the FIR, at least we know that the FIR has been filed by the
Where is
Money
the
lender.
copy of that FIR?
Lordship. They are refusing to give me the copy of the FIR, Lordship.
my lord,
I have made efforts still yesterday.
may I please, your lordship, my lord, here, there is no FIR and there is no case number, so it is finding difficult to communicate with the, it will be finding difficult to communicate with the police.
No, you.
Yes, my lord.
You inquire whether so and so, I will mention it in the orders, what is to be found out by. You telephonically take instruction from the officer in charge of Kohima North Police Station and intimate this code by 2. Then we will pass orders.
Lordship.
Mr.
My lord, then kindly allow me 30 minutes, because after 12 I have to go out of station to meet one of my brother who got accident, my lord. So,
Okay, then what is the submission?
so let the matter be taken up after 30 minutes.
Okay.
Yes.
Okay. By that time you will find.
Yes, my lord.
Okay, we'll again take it up at 12:30.
Okay.
My lord. I am deeply
You
obliged.
just inquire whether the petitioner, the private respondent has filed any FIR has been lodged against the petitioner, because the submissions of learned counsel for the petitioner is that on 6th he was
Called by
summoned-
the IO.
called by the
I have
IO
also given the,
or telephonically.
yes, the name of the IO here, Lordship.
You will furnish that name to Mr. Tibafo.
Lordship.
Okay, Lordship.
We'll take up this matter at 12.
In paragraph
Yes.
4, in paragraph 4.
Both the cases are same.
Yes, one is the principal power, the other is the calendar.
Okay, at 12:30 we'll take up.
Yes, Lordship.
Much obliged.
For hearing item number 33.
May please, Lordship.
You are ready?
Yes, Lordship.
Mr. Angami, you are also ready?
Yes.
Yes. Yes.
Lordship. Lordship, the petitioners altogether 18. They are approaching 18, 1-8, Lordship. They are approaching this honorable court. They are grieved by a reject list, which was published in the year 2020. Lordship, what has happened was, Lordship, there was an advertisement for filling up 18 posts of laboratory technician. Lordship, this happened during that COVID time, Lordship. Well, take your Lordship to the advertisement first.
Yes.
Lordship will find page 21, annexure D. Page 21, annexure D.
Yes.
Page 21.
Yes.
This is an advertisement issued in the month of July 2020, and it was issued by the Directorate of Health and Family Welfare, Nagaland, Kohima. May I read it, Lordship?
Yes.
In pursuance to notification number so-and-so dated 3rd of July, applications are invited for recruitment against existing vacant posts on regular basis under the Department of Health and Family Welfare through the Department Recruitment Board in the manner prescribed below. Name of post, laboratory technician. Number of posts, 18 in various health units. Pay metrics, so-and-so, so-and-so. Now, Lordship, it says that the terms and conditions and the prescribed format of application can be downloaded from the department website, so-and-so, so-and-so is there. Now, if your Lordship may kindly come to the next page, that is the typed copy of the advertisement and the terms and conditions, Lordship will find page number 23. The terms and conditions, and this is very important, Lordship. Terms and conditions, page number 23. Now, terms and conditions for lab technician, if your Lordship, correct?
Yes.
Okay. Number 1, eligibility criteria. A, those who have resigned from contractual service without any valid reasons during the COVID-19 pandemic crisis shall not be eligible to apply for this recruitment drive. That is the first condition, Lordship.
Yes.
That doesn't cover us, Lordship. Second,
That covers you.
we did not resign,
Okay.
Lord. So we don't fall under this, Lordship. The second is age as on 1/1/2020. Minimum and maximum is given, Lordship. We fulfill this criteria, Lordship. B, desired qualification. This is important, Lordship. Diploma in medical laboratory technology. We are concerned with this, Lordship. Or it's given or graduate degree in medical laboratory technology or graduate degree in medical technology with specialization in medical lab technology. The above mentioned qualification must be from an institute or university recognized by competent board, council, AICTE, UGC. So it has specified that the university has to be recognized by a competent board, council, or so and so. So this are where the conditions at that relevant point of time, Lordship. Now, Lordship, all the petitioners, they have submitted the application and they were waiting for the interview, Your Lordship. Now, what has happened, if Your Lordship, if I may be allowed to take Your Lordship to page number 25. This is the rejected list for lab technicians, page 65, Lordship. I'm sorry,
Page
Lordship.
number?
65, Lordship, my
Okay,
apologies. 65,
65.
65.
Yes.
Now, under this rejected list, all the 18 petitioners were before this honorable court. Our names features in this list. And the reason why our applications were rejected was from an unrecognized university. That was the ground for rejection, Lordship. And that is my limited grievance, Lordship, before this honorable court. Our applications were rejected simply on the ground that we obtained the diploma course from an unrecognized university.
Okay.
Now that compels me to take Your Lordship to the institute where we pursued the course, how the institute commenced, and what was the state government, what was the role played by the state government, and what are the procedures for recognition, Lordship. If I may be allowed to take Your Lordship to that aspect, Lordship. Now, Lordship, my contention before this honorable court is, it was in the year 2007, Lordship. This is very important, 2007, Lordship. The institute, Indian Institute of Paramedical Technology, Kohima, Nagaland. That is the institute, Lordship. Indian Institute of Paramedical Technology, Nagaland, Kohima, Nagaland, Lordship. I've stated a brief genesis of how the institute commenced at paragraph 4 of my read petition, Lordship.
Yes.
Now, the institute started as a recognized university, Lordship, under CELTA Training Society for Medical Research, Kolkata, Lordship. I've made a categorical statement in my petition at paragraph 4A, Lordship. Lordship will find a page number 6 of my petition, Lordship.
Yes.
Lordship, sorry to trouble Your Lordship. I'll take to paragraph 4A, Lordship.
Yes.
The Indian Institute of Paramedical Technology, Kohima, Nagaland, initially commenced as a recognized institute of CELTA Training Society for Medical Research, Kolkata, in the year 2007. Subsequently, the government of Nagaland approved the institute with approval number so-and-so. The institute was also registered under government registration number HRS 4997 under the government of Nagaland. So what has happened, the institute was recognized, affiliated under the CELTA Training Institute. Later on, subsequently, Lordship, what has happened, the government of Nagaland issued the approval, and thereafter a meeting was held, and NOC was also issued, Lordship. So basically, the institute started in the year 2007. This fact has not been disputed by the state respondent at any point of time, Lordship. The state respondent, they have filed their affidavit on 2 occasions, Lordship. 2 occasions.
What is their contention?
They are silent on this aspect, Lordship.
Now, requirement was that it should have been recognized by a competent board
Lordship,
/ council
Lordship,
/ AICT / UGC.
Lordship.
Which of these have recognized you?
Lordship, as an officer of the court, I have to assist this honorable court with the actual facts, Lordship. Now my contention is that it was initially an recognized institute under CELTA, which does not come under any of the board those mentioned by as per the advertisement, Lordship.
Advertisement.
Yes, Lordship.
Then what is your case?
Lordship. Now the second aspect, Lordship. Approval was issued by the government of Nagaland. We were in the process, Lordship, even the vice principal of the institute entered appearance and pleaded as a necessary party. They have also filed the affidavit. They have also categorically stated in the affidavit that they were in the process to get it recognized, because normally Lordship knows an institute on the day of commencement, the institute not necessarily get a recognition. we have to go through the process, Lordship. At least provisional approval has to be issued by the apex body. Now, in my case, Lordship, my respectful submission before this honorable court is that the apex body is the Paramedical Council of India. Now, the Paramedical Council of India in the year 2010, after 3 years of commencement, Lordship, in the year 2010,
Yes.
issued provisional authorization, Lordship, provisional authorization.
Okay.
And it was for a period of 6 years, provisional authorization. Subsequently, it has to be regularized, Lordship. It has to be regularized. Now, Lordship, another facet of this case is, Lordship, before expiry of the 6 years period, Lordship, the institute unfortunately closed. It was in the year 2000, between 2012-13, as per the instruction from my client's, Lordship. It was between 2012-13, Lordship.
Yes.
So, in other words, the institute had only the provisional authorization at that relevant point of time when the institute closed. It is also my respectful submission that, yes, I have to consider the fact that it was not regularized. Authorization was not regularized, Lordship.
It was till 2016.
Lordship, 2016.
Okay.
If I may be allowed to take Lordship to some documents, just 2, 3.
No, before that, what is
Lordship,
your case?
my case is
It
that,
was
Lordship,
not regularized. Then
my case is that there are similar situated cases, Lordship, which was taken up before this honorable court also, where the employees, even before recognition of such institute, could underwent the course, they are allowed to continue, or maybe they are allowed even to participate in any other regular selection process. There's a similar situated case, Lordship, if I may be allowed to place before this honorable court. The facts is very simple, Lordship. It is pertaining to the state of Assam, Lordship.
but in this case, after provisional recognition by Paramedical Board of India,
Lordship,
Paramedical Council of India,
Lordship,
it was not regularized.
It was
So-
not regularized.
So the approval was not extended beyond 2016.
Lordship.
And when the petitioner underwent the course, when they did the course before,
Lordship, altogether 18 petitioners, so they undertook the course on different occasions, Lordship,
before regularization or after?
before regularization, Lordship. Some, the senior most, they started in the year 2007 and completed in the year 2009, Lordship, even before the NOC was issued. I consider fact, Lordship.
Okay.
Some, because initially the commencement was under the recognition of CELTA Institute.
So how the authority is wrong in rejecting your petition?
Now, Lordship, subsequently what has happened, Lordship, NOC was issued by the government of Nagaland, Lordship, NOC, for establishment of the institute, and also approval was also issued by the government of Nagaland. There was no issue at that relevant point of time, Lordship. Of course, subject to fulfillment of certain criteria for any institute to get recognition, Lordship. Now, several inspections were also conducted, Lordship. Now, as far as the first inspection is concerned, Lordship, the inspection report states that the institute fulfills all the eligibility criteria to run as a full-fledged institute, Lordship. Subsequently, what has happened, Lordship, I'm yet to know about the facts. But as far as the present petitioners before this honorable court are concerned, Lordship, it was within that intervening period, Lordship, we got the diploma course, Lordship.
Intervening period when there was no recognition.
Lordship.
But that is one of the eligibility criteria, that your diploma or graduation has to be from an institute which is recognized.
Lordship. I agree,
So
Lordship.
how you will overcome?
Lordship, my respectful submission before this court, the plight of the students, Lordship, because now if I have to undergo the process, Lordship, I'm already overaged.
No, but
Some
this
of us
is,
are already overaged,
laboratory technician.
Lordship.
You will be testing what ailment other patients are
In
suffering.
fact, Lordship, the government of Nagaland utilized our services at the time of COVID-19 pandemic, Lordship. And they utilized the service to the fullest potential, Lordship. In the sense, Lordship, there were no one, Lordship. There was no one to sacrifice their time, their service.
So
They
you
have
will
utilized our services.
engage technicians from unrecognized.
Lordship, yes,
The-
Lordship.
What is why the necessity of recognize undergoing training in a recognized institute is there? Otherwise, everybody will start issuing diploma.
Lordship, I have no argument on that, Lordship. I have no argument on that. Just the fact that at the time when the whole world was facing the problem of pandemic and Lordship, the goal over Lordship. They were in need of the service, Lordship. Now that question did not arise at that point of time. We were engaged on contract services, Lordship. Lordship, some of us, we are still engaged in private sectors. And even, under Lordship, under flagship programs under the Medical Institute, Lordship. Or maybe under the Health and Family Welfare Department, Government of Nagaland, Lordship. They still engage us on contract basis. They have utilized the services at that relevant point of time, Lordship. Now, Lordship, if I may be allowed to just refer to the citation which I've placed, it is similarly situated, Lordship.
Yes. Yes.
If I may be allowed to refer to paragraph 1 of the authority that I've just placed before Lordship. Regarding the facts, paragraph 2, Lordship. Facts. Just a short fact, Lordship. Paragraph 2. May I read it, Lordship?
Yes.
The petitioner, Mr. So-and-so, based upon his qualification and eligibility, seeks to be the principal of so-and-so secondary school. The petitioner participated in the selection process for the post of principal as per the advertisements so-and-so, and states that in the selection process, he was otherwise the first selected candidate in order of merit. But by the order impugned dated so-and-so of the Director of School Secondary Education, Assam, the respondent number 7, who has the qualification of MSc B.Ed and is a postgraduate teacher at so-and-so, was appointed as a regular principal of the school. 3, the petitioner so-and-so early instituted a selling the communication dated by which the present respondent number 7 was appointed as the regular principal of the school. In the said read petition, it was the stand of the petitioner that he had the qualification of postgraduate degree as well as a B.Ed degree. And therefore, he was duly qualified to be appointed as regular principal of the school, but ignoring his claim, the respondent 7 had been appointed as the regular principal of the school. In the state read petition, it was the stand of the state respondents in the secondary education department that the petitioner was not appointed, inasmuch as his B.Ed degree was not a valid degree under the law. Accordingly, the order dated so-and-so, the matter was remanded to NCTE to examine as regards the validity of B.Ed degree of the petitioner. In response thereof, the NCTE took a decision in the minutes of so-and-so to refer the matter to Secretary Department of Education, Government of Assam, and to the registrar of the concerned affiliated body, which has to be understood to the so-and-so. So in short, the fact is, the B.Ed degree was not from a recognized university. That is the ground for rejection of his candidature, Lordship. Now coming to the relevant paragraph, Lordship, paragraph number 17, Lordship. Lordship will find a page number 9.
Yes.
May I read 17, Lordship?
Yes.
A reading of the proposition of the Honorable Supreme Court makes it discernible that a course that was undertaken in that given year when the recognition was refused would have to be allowed to be continued, and whoever acquires a B.Ed degree pursuant to such course undertaken would be a valid degree. Nothing can be read in the proposition of the Honorable Supreme Court that the final examination also has to be passed at the end of the year itself and not later, inasmuch as the relevant aspect of consideration is the course that was undertaken in the given year and not the examination which was passed. Accordingly, by placing complete reliance on the proposition laid by the so-and-so, we are unable to accept the views of the respondents in the Secondary Education Department that the degree obtained by the petitioner in the circumstance narrated above from so-and-so would be an invalid degree under the law. Accordingly, we remand the matter back to the so-and-so to examine the claim of the petitioners regards his claim for appointment as regular so-and-so. In doing so, the respondent so-and-so has already been appointed so-and-so, due hearing under the law to be given to so-and-so. The requirement of considering the acceptability of the B.Ed degree of the petitioner be done by the director within a period of 2 months from today, and whatever decision be taken shall be strictly in terms of all such applicable law, including the principle of natural justice in respect of all the parties.
What was the logic? What was the principle?
Lordship, here, at that relevant point of time that the institute in question here in this case, Lordship, it was not a recognized university.
It was not a recognized.
Lordship, it was not a recognized university.
Then
Later on, Lordship, it got the recognition, Lordship. Now, for those students, Lordship, who took the course at that intervening period, Lordship, they are directed to be considered.
on what basis? What was the basis for this direction?
The proposition of the Honorable Apex Court saying
Now,
that.
what was the
plus-
logic of the apex court?
Lordship, subsequently, because they have to undergo a process for recognition. On the day of commencement, the recognition cannot be allowed, Lordship.
No, what proposition was laid down by the apex court in this case, which you are
It is at paragraph 17, Lordship. Or
70?
15 also, Lordship. Paragraph 14 and 15, Lordship.
Yes,
May I read 15 first, Lordship?
yes.
A reading of the proposition laid down by the Honorable Apex Court.
What proposition was laid down? That is my question.
Yes, Lordship, yes, Lordship. I'm coming to that, Lordship. Does not make it discernible that there is also a requirement to obtain the B.Ed degree at the end of the academic session itself. The Supreme Court provides that whatever course was undertaken by the students in that given year, when the recognition was refused, that course would be continued till the end of the session. And whoever obtains the degree by pursuing such course, that degree would be a valid degree in law. For more clarity, if I may be also allowed to read paragraph 13, Lordship.
Yes,
13. A conjoint reading of the proposition laid down by the Honorable Supreme Court in so-and-so case. A proposition of law can be called out that in the event a student acquires a B.Ed qualification from an institute which is not recognized under the law, such degree would be invalid degree and cannot be used for any further purpose. The aforesaid proposition of law laid down by Honorable Apex Court is of a general nature that when a B.Ed degree had been obtained from an institute which is not recognized under the law, such B.Ed degree would be invalid. But in the instant case, in the contention of Mrs. So-and-so, learned counsel for the petitioner that a proposition laid down by so-and-so is under specific circumstance as regards that what would be the implication under the law of a degree of B.Ed if it is obtained from an institute where an application was made before so-and-so for its recognition, but later on within the session itself, it stood rejected. It was rejected, Lordship. As per the proposition laid down by the Honorable Apex Court and so, even if an application by an institute seeking recognition is refused, the course that had already been offered for that given year or session would continue till the end of the session, and it is not to be understood that the course stands discontinued upon the recognition being refused, and further, whoever obtains a B.Ed degree by undertaking such course is that in that given year would be entitled to a degree or a certificate. My only respectful submission before this and report is the apex body, the Paramedical Council of India, accorded provisional authorization to the institute, Lordship, for a period of 6 years. 6 years expired in the year 2016.
Now your cases were rejected, your applications were rejected. What
Rejected.
happened to the recruitment process?
Lordship, it has become infractious as far as that advertisement process is concerned, Lordship. It has
Then-
become infractious.
Already selection is over.
Lordship, appointment issued and
Then what will
placement
you-
done, Lordship. Nothing remains. Only prayer number C remains, Lordship. At least allow us to participate as far as those batch of the students are concerned, Lordship. Till such time,
Prayer, what is prayer number C?
Lordship, if your Lordship may kindly allow me to take your Lordship to page number 14. As far as A and B is concerned, Lordship, it has already become infractious, Lordship. C. Director respondents to recognize or accept a petitioner's course of diploma and so and so for any future participation in selection process,
Okay. So academic,
Lordship.
so that your degree may be recognized,
Lordship.
treated as a recognized degree.
Lordship. Or at least they can consider my applications along with the diploma courses in the near future, Lordship. A simple direction figures as far as the present petition is concerned, Lordship.
And your main ground is as because provisional approval recognition was granted by the,
Exactly, Lordship.
and some of the petitioners had undergone the course when the provisional recognition was in force.
Lordship.
Is that your case?
Yes, Lordship.
Then you have to be specific on dates, that when the provisional recognition was granted,
Lordship.
when each of the petitioner took admission and
Lordship,
completed.
Lordship. I can provide the petitioner numbers, Lordship,
Yes,
who falls under that intervening period, Lordship.
yes,
I can provide that petitioner numbers, Lordship.
because others may not get benefit.
Yes, Lordship. As far as petitioner number 1 and 2 concerned, Lordship, they took admission in the year 2007, Lordship,
Then
before according the provisional authorization, Lordship.
Then they will not get benefit.
Lordship, I cannot go beyond that, Lordship. I have to be very honest before this number call, Lordship.
Anything else?
Lordship, that is my limited prayer, Lordship.
Only this judgment you are relying.
Lordship.
Yes, government side. They are pressing for only prayer number C.
Yes, Your Lordship. And I have a strong objection to prayer number C, my lord.
What is your ground?
Lordship, my learned friend has gone through almost all the documents, but however, in order to substantiate my submission at the course of repetition, allow me to go
You
back.
have to furnish in a piece of paper, in a
Lordship.
short note,
Lordship.
that petitioner number 1 took admission on this day.
Lordship, Lordship.
He passed out on this day.
Lordship.
And during this time, the provisional recognition was in force.
Lordship.
Each of the petitioners.
Lordship, Lordship. Lordship, I'll provide that. Lordship, even otherwise, I have also enclosed the certificates in my read petition, Lordship.
You refer to those certificates in that small note,
Lordship, Lordship.
written note.
I'll definitely do that, Lordship.
Yes.
Obliged,
May,
Lordship.
may I please, my lord? Lordship, the present petitioners are claiming to have completed a diploma course, as stated by my learned friend here, from the Indian Institute of Paramedical Technology, Kohima. Now, this institute, Your Lordship, this institute, as per the submission and as per the contention of the petitioner, is recognized by the government of Nagaland. And the ground that it is recognized by the government of Nagaland is taken by the petitioner that because an NOC was issued by the government, by the state government, and therefore the state government recognizes this particular institute, Your Lordship. Allow me to take my lord to the no objection certificate issued by the state government, which Your Lordship will find in the page number 19 of the read itself, my lord. Page 19, my lord.
Yes.
I may be allowed to read this, my lord.
Yes.
no objection certificate. This has been issued by the Department of Higher and Technical Education, Government of Nagaland. And the issue date is 2nd of July 2010.
Yes.
And it says, Your Lordship, the undersigned is directed to convey herewith no objections of the government for establishment of Indian Institute of Paramedical Technology at Kohima. So no objection was issued for the establishment of the college. Recognition has to be taken by the institute from the concerned council. This no objection is in no way giving recognition to the institute. It is just for the establishment, Your Lordship, nothing more than that. And therefore, the state government has recognized this institute is wrong, Your Lordship. Now coming to the advertisement, Your Lordship. Allow me to take my Lordship to the advertisement. Lordship, the Directorate of Health and Family Welfare, Government of Nagaland, has advertised 18 posts of laboratory technician through an advertisement that the 16th of July 2020. Your Lordship will find it at page 21 and 22. Now, Your Lordship, my learned friend has already read it. However, I would like to take my Lordship back to the eligibility criteria.
Yes.
I'm concerned with eligibility criteria 1B, that is the desired qualification. Now it says diploma in desired qualifications, diploma in medical laboratory technology, or graduate degree in medical laboratory technology, or graduate in medical technology with specialization in medical laboratory technology. Lordship, the required qualification for the 18 posts that has been advertised is either a diploma in medical laboratory technology or a degree in medical technology, medical laboratory technology with specialization, if any. Then, Your Lordship, this particular diploma course, degree course, has to be done from an institute or a university which has been recognized by the competent board, council, AICTE, UGC. In this case, Your Lordship, it is the Paramedical Council of India. So we are concerned with council, Your Lordship. Now, Your Lordship, pursuant to this advertisement, the petitioner applied for a post and their names was rejected on the ground that they have obtained the diploma certificate from an unrecognized institute. No, Your Lordship.
Yes.
Now, whether this particular institute is actually recognized or not, Your Lordship, and what steps has the state government taken, Your Lordship? Allow me to take my Lordship to the affidavit filed by the state respondent, Your Lordship. There are two affidavits filed, Your Lordship. The affidavit filed on 26/2023. This is the relevant affidavit I'll be referring to, my Lord. This is actually an additional affidavit on behalf of the state respondent 1 to 4.
Yes.
Now, Your Lordship, even after issuance of the NOC for the establishment of this council, and therefore, Your Lordship, meetings was held, decision was taken in the meeting. I would like to take my Lordship to page 15, annexure B of my affidavit in opposition, Your Lordship.
Yes.
Now, this is a minute of the meeting held on 26th of May 2011.
Yes.
I may be allowed to read the relevant para of this particular meeting minutes, my lord.
Yes.
The first para. Your Lordship. A joint meeting of the officers of Health and Family Welfare Department and Higher and Technical Education Department was held on 11th hours on 26th of May 2011 in the office chamber of the Commissioner and Secretary, Higher and Technical Education, Nagaland, to discuss issues arising out of no objection certificate issued by the Higher and Technical Education for starting 2 paramedical institutions in the state. Para 2, my lord. Sri F.P. Salo, Commissioner and Secretary, Higher and Technical Education, welcome all its officers of the department to the meeting. At the very outset, Your Lordship, he pointed out that no objection certificates are being issued by the department for the limited purpose of facilitating setting up of higher and technical education institute in the state. However, it is the responsibility of the institutions to obtain necessary approval permissions from the concerned regulatory bodies like Nagaland University, University Grant Commission, National Council of Teachers Education, All Indian Council of Technical Education, Medical Council of India, Paramedical Council of India, etc. The department has issued no objection certificate to the Indian Institute of Paramedical Technology, Kohima, and Nagaland Paramedical Institute, Singrijan, Dimapur, to help them set up paramedical institute in the state. But issuing no objection certificate to set up an institute doesn't mean that the course offered by the institute are recognized by the state government. They claim that the institute is recognized by the department is misleading. Para 3, my lord. Representative from the Health and Family Welfare Department stated that the students who pass off from the two paramedical institute are applying for government jobs, but on checking the records of the institute approvals, recognitions from the concerned regulatory bodies like the Paramedical Council of India or Indian Nursing Council is wanting in both the cases. The students who pass off from these 2 institutes cannot therefore be considered for employment in the department. The 2 institutes also lack the basic required infrastructures and facilities. Your Lordship, this is the decisions taken, para 4. After detailed deliberation, it was unanimously decided that 1, to counter the misleading publicity of this by the 2 institutes, the public should be notified through the local press that the course and certificate issued by the Indian Institute of Paramedical Technology, Kohima, and Nagaland Paramedical Institute, Singrijan, Dimapur, are not recognized by the Department of Health and Family Welfare for the purpose of employment in government. However, before doing that, the Department of Health and Family Welfare will issue show cause notice to the 2 institutes first. 2, the Department of Higher and Technical Education will advise the 2 institutes to get necessary approval recognitions from the competent regulatory bodies like the Paramedical Council of India and the Nursing Council of India. So even in a meeting that was held on 26th of May 2011, it is very clear that the institute has not been recognized. Thereafter, Your Lordship, even after this, meetings was held again, Your Lordship, and certain other decisions was also taken, Your Lordship. Your Lordship will find that on page 19.
Yes.
Now, this is a minutes of the meeting held on 25th of July 2011.
Yes.
I will be reading only the relevant para again, Your Lordship.
Yes.
Minutes of the meeting held on 25th of July 2011 at 3 p.m. in the Chief Secretary Conference Hall pertaining to IIPMT. Your Lordship, this IIPMT means Indian Institute of Paramedical Technology, Kohima. We are concerned with this. And IMMRHS and Singrijan, Dimapur, Nagaland. First para, my lord. A meeting was convened under the chairmanship of the Chief Secretary to discuss the issue pertaining to the accreditations, recognitions of the Indian Institute of Paramedical Technology and in an Institute of Management, Medical Research, Health Science and School of Nursing, Singrijan. The issue pertains to the facts that in the absence of accreditations, recognitions, students passing out from these 2 institutes are not eligible for employment in their trades. Lordship. Para 4.
Yes.
Para 4. Your Lordship, para 4 and 5 are important. Para 4. Dr. R. Zina, Principal, IIPMT. This is the institute, Your Lordship. Kohima said that the institutions was started as per the needs of the paramedical worker, more so in the rural area with the coming of NRHM. He also said that the management board of these 2 institutes has been complacent for not taking up the issue timely with the state authority. He requested the health department to give permissions to the students to have a hand-on experience in the government hospitals as they do not have private hospitals to get practical knowledge. He's admitting, Your Lordship. The principal himself is admitting. Para 6, Your Lordship.
Yes.
Para 6. Sri A. Wapan Lota, Additional Secretary from the Technical Education Department, Dr. Kanlo Mak, Additional Director, Health and Family Welfare, Dr. A. Jingyong Pom of IIPMT. This is the respondent number 5 hearing, Your Lordship. Dr. A. Jingyong.
Yes.
MS Wangshokla Jamir of IMMRHSM also took part in the deliberation. Your Lordship, the next para, the next line. Dr. A. Jingyong Pom stated that the students be given a chance to appear in the interview, which was not agreed to. All along, Your Lordship, all along, the institute was never recognized. Then thereafter, Your Lordship, the department, the government has constituted a 3-members committee to look into the infrastructures as well as the recognition of that particular institute, which Your Lordship will find it at page 23, annexure D.
Yes. What is this?
This is a notification. I may be allowed to read this, my lord.
No, you may tell me what is this?
This is a notification by which a 3-members committee was constituted to look into the recognition as well as the infrastructures of the concerned institute and the report submitted therein, Your Lordship.
Because
Yes.
Committee was.
Committee, yes. Para 5, the last para, if I may be allowed to read this then.
Yes.
Now, therefore, the above 3 institutes, Your Lordship, the 3 institutes are mentioned at para 2.
Including the Institute of Paramedical.
Correct, Your Lordship. Correct. May I read para 2, my lord?
Para 5.
Para 5. Now, therefore, the above 3 institutes are hereby directed to get necessary approval, permission from the concerned regulatory bodies within 1 year time, failing which then no objection certificate given by the government will be withdrawn. The institute are also directed not to admit fresh batches of students till necessary permission for running various courses is obtained. Thereafter, Your Lordship, a show cause notice was issued to the institute. Your Lordship will find that at page 25.
Yes.
Your Lordship, this is a show cause notice dated 16th of May 2014.
Yes.
Para 1 and 2, Your Lordship. Whereas the government of Nagaland Department of Higher and Technical Education has given no objection certificate to the following paramedical institutes in the state to start various courses in a paramedical technology. Your Lordship, we are concerned with number 3, Indian Institute of Paramedical Technology, Kohima. And whereas, Your Lordship, number 2, and whereas the no objection certificate were given to the above 3 paramedical institutes only to felicitate establishment of the institute. Approval and recognition of the course offered by this institute fall within the purview of the regulatory bodies such as the AICT, NU, NCI, MCI, Paramedical Council of India, etc. And the no objection certificate issued by Department of Higher and Technical are in no way to be construed as approval or recognitions of the course by the state government. Para 5. And whereas the inspection committee has submitted its report to the government with a finding that the 3 institutes lack proper no objection certificate from the competent regulatory bodies, sufficient land and infrastructures, including administrative blocks, academic classrooms, library, laboratory, conference hall, computer and computer room, basic environment sanitations, safe drinking water, proper water supply, proper hygienic toilets, minimum basic facility for physically challenged people, overhead projectors, qualified facility members, and qualified examiners for conducting examinations. A copy of the inspection report is enclosed for reference. Now, therefore, Your Lordship, last para. The 3 above mentioned institutes are hereby called upon to explain as to why the no objection certificate given by the state government should not be withdrawn within 15 days from the date of receipt of the publications of this show cause notice. The institutes are further directed again The institutes are further directed not to admit fresh batches of students until further order.
You don't even have qualified faculty members.
Correct.
Apparently, Lordship. Lordship, may
So-
kindly appreciate one fact, Lordship. Before the NOC was issued, there was an inspection conducted, Lordship, because the institute commenced in the year 2007. NOC was issued in the year 2010, Lordship. So there was an inspection, the first batch, Lordship. Basing on the inspection report, the NOC was issued. Later on, Lordship, I consider the fact that about what my learned friend has just apprised before this honorable court about the subsequent inspection report, Lordship. I have no say on that, Lordship. But my respectful submission is that, Lordship, the institute started in the year 2007. NOC was issued in the year 2010, based on the inspection report submitted by the competent authority, Lordship. And there was also subsequent inspection, Lordship, which my learned friend has relied upon. I have no say on that, Lordship.
May I continue, my lord?
Yes.
Now, your lordship. So apparently from all these documents, your lordship, that I have just read it out, it clearly shows one thing alone, that is the institute is not a recognized institute, my lord. Now, your lordship, allow me to tag my lord to the authorization letter, page 20 of the writ petition.
What is this?
Authorization letter from the Paramedical Council of India. What authorization is being given by the Paramedical Council of India? I wanted to project this before my lord.
Okay, this is important.
Yes. This is the authorization letter dated 31/7/2012.
Yes.
Your lordship. It is written to the principal, Indian Institute of Paramedical Technology, Kohima. Subject, your lordship, your application for authorization to conduct paramedical courses. It is to conduct paramedical courses, your lordship. And that also, there is a condition prescribed therein, your lordship. Sir, we are pleased to inform your caption application, your lordship, for establishment of authorized studies center of our Paramedical Council India has been provisionally accepted, subject, your lordship, subject to payment, submissions of all requisite fees and documents thereafter, inspections of your centers by Council Inspection Committee. Your lordship,
Yes.
the next para, your provisional authorization number, which must be mentioned in all correspondence with the council. Third, this authorization subject to annual reviews and renewals is valid for a period of 6 years from the date of granting regular authorization. See, your lordship, valid for 6 years from the date.
6 years provide subject to annual review.
Yes,
So every year it has to be reviewed
Correct.
and renewed.
correct. Not only that, your lordship, not only that, my learned friend has left out a most important paragraph. Your lordship, come to the last paragraph. It starts with note. Note.
Yes.
I may be allowed to read this. Note.
Yes.
Your authorization for study center is not at all affiliation. Is not at all affiliation. You will therefore never in publicity, correspondence, or even in convention proclaim yourself as affiliated to our council. Stringent action will be taken for violation to this. It is not an affiliation. So it is clear now, your lordship, the institute is not a recognized institute. That comes to the prayer C, your lordship. That brings me back to prayer C of the writ petition, your lordship. What is prayer C, your lordship? Is to direct may I read this prayer C, your lordship?
Yes.
Is to direct the respondents to recognize or accept the petitioner course of diploma in medical laboratory technology obtained from the Indian Institute of Kohima for any future participation in selection process. For any future participation in selection process, Your Lordship. Now, what does the apex court says? As far as a person who has obtained a degree from an unrecognized institute, whether they are entitled to sit for any future vacant post or not, Your Lordship. I may be allowed to place attention on that. Nineteen 3 SSC 87, my lord.
Yes, what it says.
Now, this is an appeal.
Para,
Your Lordship, the relevant para will be 5 and 6.
yes,
This is an appeal made before the apex court against the decision of the Honorable High Court, where the High Court has on an humanitarian ground allowed an unrecognized, allow students from unrecognized institute to appear the examination, Your Lordship. Allow me to read para 5.
yes,
Your Lordship will find that at page 89, if I'm not wrong, Your Lordship.
yes.
Para 5.
Page 89.
89, para 5. Your Lordship, as per the SSC online, para 5 falls under page 89, Your Lordship. It starts with after hearing counsels. It starts with after
Okay,
hearing,
Citation is State of Tamil Nadu and says Saint Joseph Teachers Training.
correct. Saint Joseph Teachers Training Institute and another.
Your para starts with
My para start with 5. I'm reading para 5.
5 is different. You read your paragraph.
Lordship, I may allow to read para 5. After hearing learned counsel for the parties, we are of the opinion.
Yes, para. After.
After hearing learned counsel for the parties, we are of the opinion, Your Lordship. My para starts with that. Your Lordship, may I read it and then place it on record?
You read it. Please read.
Lordship, after hearing the learned counsel for the parties, we are of the opinion that these appeals must succeed. There is no dispute that the respondent educational institutions was established for imparting educations in teachers training course without obtaining recognitions from the Education Department of the state government. In absence of recognitions from the Education Department, the students pursuing their studies in these institutions cannot appear at the public examinations held by the Education Department. The full bench rightly held that the students of an unrecognized education institutions could not be permitted to appear at the public examinations held by the government. On its own finding, the full bench should have refused relief to the petitioner, but it was persuaded to issue directions on humanitarian ground, which were in effect destructive of its own findings and the law laid down by it. The full bench issued directions permitting the students to appear at the examinations and directing the appellant authorities to make a special provisions for supplementary examinations. These directions, in our opinion, were unauthorized and wholly unjustified. Para 6, Your Lordship. The practice of admitting students by unauthorized education institutions and then seeking permissions for permitting the students to appear at the examinations has been looked with disfavor by this court. In NM Dangas Swararama versus State of AP, this court observed that if permissions was granted to the students of an unrecognized institutions to appear at the examinations, it would amount to encouraging and condoning the establishment of unauthorized institutions. The court declared that the jurisdiction of this court under Article 32 or of the High Court under Article 226 of the Constitutions should not be frittered away for such a purpose. In AP Christian Medical Education Society versus Government of AP, a similar request made on behalf of the institutions and the subject and the students for permitting them to appear at the examinations, even though affiliation has not been granted, was rejected by this court. The court observed that any directions of the nature sought for permitting the students to appear at the examinations without the institutions being affiliated or recognized would be a clear transgressions of the provisions of the Act and the regulations. The court cannot be a party to direct the students to disobey the statute, as that would be destructive of the rules of law. The full bench noted that these decisions and observations, and yet it granted relief to the students on humanitarian ground. Court cannot grant relief to a party on humanitarian ground contrary to law, since the students of unrecognized institutions were legally not entitled to appear at the examinations held by the Education Department of the government. The High Court acted in violations of law in granting permissions to such students for appearing at the public examinations. The direction issued by the full bench are destructive of the rules of law. Since the division bench issued the impugned order following the judgment of the full bench, the impugned orders are not sustainable in law. Your Lordship, this case squarely covered the present writ petition, Your Lordship. I have another citation, Your Lordship.
On the same point,
Yeah, on the same point. On the same point. Your Lordship, this is,
one citation would be enough.
if I have convinced my Lord, then it's okay, Your Lordship. I will not be placing it, my Lord.
Heard, Mr. Miss Lucina, you have any submission?
Lordship, I have a very brief submission. I'm appealing
You are
for
for?
respondent number 6, who is the
Ins-
ex-vice principal of the institute, my lord. Lordship, I have filed a very short affidavit. I will be basing my submissions on my affidavit only, my lord. I filed my affidavit on 9/5/24, my lord. Bishop, this Indian Institute of Paramedical Technology, Kohima, Nagaland, initially commenced as a recognized institute of Canada Training Society for Medical Research in the year 2007, my lord. And then, Lordship, as my learned friend submitted earlier, we were also issued this NOC in the year 2010, which was 3 years after the institute commenced, my lord. And then, Lordship, if I may take your Lordship to my affidavit. Does Lordship have my affidavit?
You
Page
filed your
three-
affidavit on 15th February.
9th of May 2024, my lord. 9/5/2024. Filed by respondent number 6, my lord.
Just- Yes, ma'am. You have other file? Yes, you may continue your submission.
Lordship, so, Lordship, so the
Your affidavit was filed on 9/5.
9/5/2024, my lord.
Respondent number 6.
6, yes, my lord.
Yes.
So, Lordship, the Paramedical Council of India provides provisional authorization on fulfilling certain norms and conditions, my lord. So, which we have, Lordship, we have been functioning as a full-fledged institute. In fact, my lord, I have also annexed my the prospectus of the institute, which clearly shows that we have been functioning as a fully fledged this thing.
Prospectus is issued by you.
Yes, my lord.
You
However,
yours-
Lordship,
There
since
is
it's part of
question-
my affidavit, my lord,
Question is
the, yes,
whether
my lord.
are you
I
recognized?
agree, my lord. I'm coming to that, my lord. So if I may take your lordship to page 3 of my affidavit. Lordship, I'll just take 5 minutes, my lord. My submission will be very short. Just page 3 of my affidavit, my lord. The last paragraph, my lord. The affiliation may be granted, the 5th line, my lord, of the last paragraph of page 3 of my affidavit, my lord.
Yes.
The affiliation may be granted for a permanent or temporary specific duration, and extension of time may be granted on the recommendation of the inspection team of the council. Similarly, for Indian Institute of Paramedical Technology, herein referred to as IIPMT, Kohima, such steps were taken for affiliation and recognition, Lordship. However, Lordship, unfortunately, during that process, when the process was going on, the institute was closed, my lord. Whereas the process was going on, my lord. We were under the process of. So, my lord, my
Now, what
submission
the
is,
status as of today?
Lordship, since the institute closed down, my lord,
Now it is
unfortunately, yes, my lord. And the principal of the institute also, unfortunately, he passed away, my lord. So, Worship, my submission is that the petitioners were bona fide students of the institute, my lord, and they have successfully completed the course in diploma in medical laboratory technology, my lord. So it'll be unfair for the students who acquired the course from our institute, my lords. That is my only submission, my lord.
Heard Mr. Moazamir, learned counsel for the petitioner. Also heard Mr. N. Angami, learned senior government counsel, as well as Ms. Roshino, appearing for respondent number 6. I'm reserving the judgment. The hearing concluded, judgment reserved. You give me a list
Lordship,
by
Lordship.
tomorrow.
Lordship, I already prepared the list. There are only 4 petitioners already.
Objection. I bring this attention to the
Yes,
objection.
yes. Place it. Yes, Mr. Fong.
Much pleasure.
From the supplementary cost list,
you
anticipatory
contact?
bail number 7
Yes,
of
my lord.
2025.
My lord, I'm informed that FIR was filed on 1st 10/2024. And I'm informed that the FIR has not been registered, my lord. However, the matter is under still inquiry, my lord.
Now, if it is under inquiry, why did the IO in her own handwriting ask me to bring 2 lakhs, Lordship, to the police station by yesterday, Lordship? And if I fail to do so, Lordship, I'll be put under police custody. That was what was stated to me on 13th, Lordship. I have also annexed the list given by the IO in her own handwriting, Lordship.
You bring the case diary.
Yes, my lord. Let the notice be issued, my lord. A short time may be given.
The police station is not for settling loans, my lord, with
Yes.
all due respect.
No, we are giving interim relief to you.
My lord, my lord.
In the meanwhile, we will call for the case diary.
Yes, my lord.
Case, what is the PS case number?
The case has not been
Not
registered, my lord.
registered.
Only the FIR was filed on 1/10/2024.
You submit a report.
Yes, my lord. Okay.
We will call for a report from the investigating officer.
My lord,
Okay,
my
my
lord.
Heard Mr. Senti Younger, learned counsel for the petitioner. Also heard Mr. E. Thiba Fong, learned public prosecutor, appearing for the state of Nagaland. This application under section 482 of BNSS has been filed by the petitioner, who is apprehending his arrest.
Her arrest, her.
Sorry, who is apprehending her arrest in connection with a case
FIR dated
in
01/10/2024.
connection with an FIR which was filed against him,
Her.
filed against her by the, who has filed?
Srimati Stella Pin, Lordship, I have mentioned in the
By
synopsis, second line.
by Srimati Stella Penye, PINYE,
ENYII.
ENYII on which date?
1/10/2024.
1/10/2024.
1/10/2024.
Before the officer in charge,
Before the officer in charge of
North Police Station, Kohima.
North Police Station, Kohima. Stop. The learned counsel for the petitioner has submitted that the petitioner had taken a loan of rupees 2 lakh from the first informant, Srimati Stella Pinay, on 18/7.
Lordship, the agreement to make loan was decided on 18, Lordship, and then the actual money was given to me on 19 and 20, Lordship. On 19 July, I received 80,000.
Rupees 2 lakh from so and so in pursuant to an agreement which was executed between them on 18/7/2020.
The actual amount I received was only 1,80,000, Lordship. I have also mentioned that
So
20 lakhs went to the broker. I never received that amount.
the
20,000.
loan was extended by the first informant at an interest rate of 10% per month. And Srimati Nekito, Neiktou, Nekito Nuo,
Yes, that is the younger sister.
stood as guarantor for
applicant.
the said loan.
Who is the applicant in the other anticipated bill application, Lordship.
Learned counsel for the petitioner submits that the petitioner was given only
1,80,000.
1,80,000 of the said amount, and rupees 2,000 was
20,000
20,000 was paid to the broker. It is
by the
sub-
broker by the FIR informant.
broker by the informant. Stop. Learned counsel for the petitioner has submitted that after paying installment of
20,000.
20,000 for 1 month by the petitioner and thereafter for 2 months by the guarantor,
My lord.
the petitioner defaulted in paying the loan due to financial constraint. Stop. However, on 3rd of, no, however, she received a notice dated 3/8/2024 from the informant seeking repayment of an amount of rupees 8,20,000 against the loan obtained by the petitioner, which includes the interest. Stop. Learned counsel for the petitioner has submitted that to pressurize the petitioner, submitted that the transaction and the dispute between the parties are purely of civil nature.
My lord.
However, to pressurize the petitioner, the Srimati Stella Pinay lodged an FIR before the officer in charge of North Police Station, Kohima, as well as against the guarantor. Stop. It is submitted by learned counsel for the petitioner that the petitioner got a telephonic call from one Zapuno,
Lordship, if it can be a telephone call from North Police Station,
telephone call from
North Police Station, Kohima.
North Police Station, Kohima on 6/3/2025.
My lord.
And he was summoned to the,
And she, my lord.
she was summoned to the police station in connection with the FIR lodged against her by the informant. The petitioner went to the police station along with the guarantor on 13/3/2025 where the police pressurized them to repay the said amount and were allowed to go back after executing PR bond on an assurance that they will come again with an amount of rupees 2 lakhs on 17/3/2025. You paid 2 lakhs.
No, Lordship. In fact, Lordship, I am even handling this case pro bono, Lordship.
Stop. Learned counsel for the petitioner. On 17, you did not go.
No, Lordship, due to fear, Lordship.
On learned counsel for the petitioner submits that the petitioner did not go to the police station on 17/3/2025. Now she apprehends that due to the default made by her, she may be arrested in connection with the case which is registered against her. It is further submitted by learned counsel for the petitioner that the petitioner was not even provided with the details of the case numbers as well as a copy of
The FIR and the
FIR
PR bond.
as well as GD entry, PR bond, etc. The petitioner submits, learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation. On the other hand, Mr. E. Thibafong, learned public prosecutor, Kumar Nagaland, has submitted that he inquired telephonically from the officer in charge of North Police Station, Kohima, and he was informed that Miss Stella Pini had lodged an FIR against the petitioner on 18th,
No, on 1/10/2024.
on 1/10/2024. However, he submits that he was informed that no police station case has yet been registered.
Yes.
And the police is only conducting preliminary inquiry
Yes.
in that respect. After consideration of the submissions made by learned counsel for the petitioner, as well as learned additional public prosecutor, this court is of considered opinion that perusal of the FIR lodged by the first informant and report of the officer in charge of North Police Station, Kohima, would be necessary for consideration of the instant and anticipatory bail application. Hence, the public prosecutor is, learned public prosecutor is requested to place the copy of the FIR and also a report in connection with in any preliminary inquiry made by the police in this regard on or before the next date fixed. That is,
My lord, after at least 2 weeks may be granted, my lord.
that is on 11th of April. Okay,
Okay, my lord.
11th of April.
My lord, if you can defend.
Here, now you appear.
I will appear, my lord, I will appear. If protection is given, lordship.
Consider. After considering the submissions made by learned counsel for the petitioner, in interim, the petitioner is directed to appear before the officer in charge of North Police Station, Kohima, in connection with the FIR lodged by Srimati Stella Pini within a period of 7 days from the date
My
of
lord.
this order
My lord.
and cooperate in the investigation. Stop. If she does so within the stipulated period of time, comma, in the event of her arrest, on the FIR filed by Srimati Stella Pini, comma, in the meanwhile, she may be allowed to go on interim bail of rupees 30,000 with one
Lordship,
security.
if it can be lesser than that, Lordship, they are
How much?
5,000, Lordship, because even myself,
Oh.
I'm handling this matter pro bono, Lordship.
My lord,
They are
it's just
really,
like a-
they are really in a bad financial shape, Lordship,
No, you don't have to pay the money.
yes,
Lordship,
That is only an amount,
Lordship, Lordship.
yes, my lord.
30,000 with one security of like amount
Lordship.
to the satisfaction of the arresting authority. Let this case be listed again on
10-4.
10/4/2020. In the next case, similar order,
My lord,
Yes, my lord.
she is
he
the
is the
guarantor.
guarantor,
Yes.
same order.
Yes,
Yes.
Lordship. I'm deeply
Same
obliged,
thing.
Lordship.
Much obliged.
Yes, when you mention,
Yes, Lordship, due to paucity of time, we'd like to mention item number 34 and 35 from the supplementary. This matter may be listed day after tomorrow, Thursday.
oh, no. Next week,
Next week. Okay, 25th and 26th, my senior will be outstation
then let it be after 2 weeks.
after 2 weeks.
Heard, Miss, what is your name?
Rubika Kiho.
Vika Kiho, appearing for the appellant.
No.
Appellant
Yes, the appellant.
and who is for the respondent side?
Lordship,
Also at Mr.
for the respondent number 123,
What is your name?
MT Kicho.
M.T. Kicho, learned counsel for respondent number 1, 2, and 3, as well as Mr. K.V. Angami, appearing for
Respondent number 4 and 5, Lordship.
state respondent number 4 and 5. This matter could not be taken up due to paucity of time. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Much obliged. Lordship.
The
I beg your
interim order shall
interim.
continue till next week.
First instance, that's why only on the question of law, that's why we don't put any documents. Whereas they think that we don't need it. There is no traction, no, when there is no traction. Where is the question of holding that is in 7 years old? 7 years old, we have served, more than 10 years. Only 7 years.
Item number 32. Which is
Only one item, no? I know the judges.
For admission, item number 32.
Yesterday I took some notes. It records. Nobody. Who was there is. Yes, Miss.
Yes, my lord.
Yes,
Lordship, I pray for my lordship, diligent and patient hearing that has been exposed from my lordship, that I may be allowed to continue my submission before my lordship. First of all, yesterday lordship was asking me to, on the provisions of filing an IA in raising preliminary objection. That was what yesterday my lordship has.
that may not have any relation with this case
Yeah, lordship.
directly, but
It's a common practice, lordship, common practice where, say like section order 14, rule 2, and order
common practice.
common
which
practice,
is
lordship, common practice.
By
And
not,
also,
not filing WS, but raising the preliminary.
yes, lordship.
Objection by filing an interlocutory.
Interlocutory order. Those are the practices because those things come under section
That
20
needs to be rectified.
and lordship section CPC. Section 26.
Yes. CPC. Yes.
This is section 26.
Blue color book is there. Yes.
My lord will appreciate that order 7, rule 11, rejection of plaint after the civil suit is filed, rejection of plaint is filed by the opposite defendants. Likewise, order 14, rule 2, also court to pronounce judgment unless preliminary issue is raised. Also, these are the section, apart from other section where in civil suit, in IAs are filed, and that comes within the purview of section 26 of the CPC. Section 26, my lordship has got it.
Yes.
Section 26 says, every suit shall be instituted by the presentation of a plaint or in such other manner as may be prescribed. So under this general provision, lordship, IA are filed and most of the preliminary objections are filed in a separate IA application. That is one thing. My lord will kindly, that is my first clarification. The second clarification of yesterday is, my lord was, yesterday my lord was of the view that this revision petition was filed under 227. My lord was mentioning yesterday, but their revision petition has been filed under section 115. My lord will kindly come to section 115, read with 151 of the CPC. I just want to appraise my lordship and impress my lordship that section 115, under this limited provision, revision under section 115, that will be 115. May I read out, lordship?
Yes.
The High Court may call for record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto. And if such subordinate court appears, Lordship, that will be the district and session judge in the first appeal that under challenge, to have exercised a jurisdiction not vested in it by law. That is one, it is limited, Lordship, limited jurisdiction. B, to have failed to exercise a jurisdiction so vested, or C, to have acted in exercise of its jurisdiction illegally or with material irregularity. These are the three principles. The High Court may make such order in the case as it thinks fit, provided that the High Court shall not, under this section, vary or reverse or order made or any order deciding an issue in the course of a suit or other proceeding, except where the order, if it has been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings. So under this specific provision, they did not approach this honorable court under Article 227. They filed this revision petition under Section 115 revision, which is limited. And if we go and peruse this, Lordship, in the impugn order that they have, impugn order 18/11/2024 of the Learned District and Session Judge, Lordship, is there any legality? Is there any irregularity? Because Lordship will kindly see that it's only basing upon the authority of the Supreme Court. The Learned District and Session Judge has stayed the injunction order, vacated the injunction order, and the records are sent back to the lower court because the civil suit is pending in the lower court to decide on preliminary objection on the issue of
One state. Okay, after we rise, let him ask to find out. Yes.
So the issue of jurisdiction, I have the authorities, but Lordship, I will just, in my first instance, I will satisfy my Lordship. I will try my level best not to be, if you can convince them not to confuse you, if you don't convince them, don't confuse them. I will not use that tactics, Lordship. So they have approached the civil suit on the basis of Sumi Ho Ho Constitution. Only on the strength of that, my Lord, yesterday I have already shown my Lordship. Under no section, they have filed a civil suit. Only on the strength of basing upon the Sumi Ho Ho Constitution, they have approached the Learned Trial Court. Now, Sumi Ho Ho Constitution, Lordship will kindly come to, I will base my submissions only on the point of law and on the Constitution of Sumi Ho Ho. I'm not going to go around, hanging around the bush, Lordship. Now, my Lord will kindly come to Article 8.1.
Page number?
Page number 8.1 is at?
You are taking up the revision petition.
No, Lordship. I have my own interpretation because
From where I will find?
my affidavit in opposition,
Page number?
page number 22, annexure E1.
That is the interpretation. The local dialect, that I may not show my lordship because my lordship will not understand the local dialect. So my interpretation, yesterday they were using their own interpretation. And why I say that I have interpreted my own is because that will, that the trial court, it will come before the trial court. However, lordship will kindly appreciate that there are some important misinterpretation, but
Yes.
that will come later on.
Which-
So this is my interpretation.
Which,
My lord will kindly come to Article 8.1. 8.1, page 26. My lord has got it. Page 26. These are the crucial issue before this honorable court, lordship. I will base only on the constitution, on the point of law, under the CPC as well as the constitution.
Yes.
Article 8.1 of the Constitution of Sumi Ho Ho. 8.1, the search committee shall consist of 7 members. 1, President Western Sumi Ho Ho. That is, President Western Sumi Ho Ho pertains to Western side, lordship, Dimapur, Newland district. Those are Sumi tribe domicile down Western side domiciled. And they are independent from Sumi Ho Ho. Although under Sumi Ho Ho, they are autonomous body. They have their own constitution. Others they don't have, but Western Sumi Ho Ho, President Western Sumi Ho Ho. So this President Western Sumi Ho Ho, he represents the whole Sumi tribe on the western side of Sumi. 2, President Sumi Kakami Ho Ho. This is President of Sumi Kakami. My lord will kindly appreciate that in Nagaland, the tribe of Konyak and Sumi tribe. Sumi tribe. These are the only 2 tribes who have hereditary chieftainship, kingship. These are the only 2 tribes of all the 17 tribes in major tribes in Nagaland. So Sumi tribe and Konyak tribe are the only 2 tribes who have hereditary kingship, hereditary practice, lordship. So Sumi Kakami Ho Ho means every village, Sumi villages, every village has 2 to at least 6 or 7 GBs, that is Gaun Buras, that was given by Britishers. However, Sumi Kakami Ho Ho means that is from the forefathers inherited, inherent, and that is to the line kingship, lordship. So Sumi Kakami Ho Ho, that is the head Kakami kings of all the villages of Sumi tribe. Serial number 2 is that president. I'm just trying to impress my lordship. Who are the search committees under Article 8.1? 3, President Sumi Totimi Ho Ho. This is all the women folks comes under this Sumi Totimi Ho Ho, Sumi Mothers Association. Serial number 3. So they govern all the Sumi women, including me, my lord. 4, President Sumi Kipimi Kakulu. 4, that is President of all Sumi Students Union. Serial number 4. The head frontal organization of the students of all Sumi students. 5, President Sumi Officers Union Nagaland. That is all the officers amongst the Sumi tribe. So President of Sumi Officers Union all over Nagaland.
That is at serial number 5. At serial number 6 is Chief Advisor Sumi Ho Ho. Chief Advisor Sumi Ho Ho is the previous incumbent president. He becomes after he relinquished the office of the Sumi Ho Ho president, he becomes the chief advisor for the next tenure. That is a traditional practice, Lordship. So serial number 6 is the President Advisor Sumi Ho Ho. 7, President Sumi Literature Board. Now that is Sumi Literature Board means in order to promote Sumi language, local dialect. These are also the frontal organization. They man the linguistic Sumi language literature board. So these are the 7 frontal organizations. These are the 7 frontal organizations, and Sumi Ho Ho is the highest apex body under which these 7 presidents are the selection committee, search committee. So that is clear, my lord. Now, these are the search committee. My lord will kindly, these are the constitution of search committee under Article 8.1. Now, Article 7.3. If my lord will kindly come to page 25. 7.3. My lord has got the 7.3. The office bearers shall be selected by the search committee and shall be presented before the House for approval. So these 7 highest frontal organizations under the Sumi Ho Ho are the 7 search committee members who, without any application, without any election, they come together, they sit together, and they make a resolution. They will bring all the, those who amongst the tribe, those who appears to be having a leadership quality in every aspect, lordship, they will bring all the, they will choose and select among the Sumi. There is no specification that he or she is such criteria, so, but those who can lead the Sumis, those who can be the president, the leader, the head of the Sumi tribe, they are selected without any application, without any election, and it is only the 7 search committee members who select the Sumi Ho Ho president. That much, lordship. Sumi Ho Ho president is selected by this 7 frontal organization. Now, as per this Article 7.3, they by resolution dated, my lord will kindly come to page 25, page 100. These are the documents that I annex in the first appeal before the learned district and session judge. But all these documents, they, page 100, they did not annex this annexure of the present respondent, suppressing the material facts. And that's why in my paragraph, I have stated that these are the documents that was filed before the learned district and session judge, but they concealed it. That's why here I have annexed all the documents that was filed before the learned district and session judge, as well as I have taken some additional documents that is crucial to the present case, lordship. So the selection committee, and my lord, when we talk about jurisdiction, here is what it comes. This selection committee on 25/7/2024 in a resolution, this is the resolution in English is at page 101, Lordship. Since there is a little bit of a local dialect involved, so my Lord will kindly come to page 101. Sumi Ho Ho Office Bearers Selection 2024 to 2027 for 3 years tenure, Lordship. Final judgment of search committee deliberations. It's in accordance with section 7.3 and section 8 of the Sumi Ho Ho Constitution, and by the authority vested under these provisions, the office bearers for the Sumi Ho Ho for the term 2024 to 2027 are hereby selected. Lordship. President, Dr. Vihuto Asmi, the present respondent number 2, Lordship. And within bracket, my Lord can will see Atoize. Has my Lord got it? Atoize. This means there are areas representative of all the subdivisions and districts. So only those who are the executive members of certain areas sent by their own area only can become the office bearers, be it president, general secretary, or any other office bearers that becomes the Sumi Ho Ho office bearers. Only the selected by the areas, they can become, and when they are sent as a representative to Sumi Ho Ho, only they can be selected as office bearers. No individual, no outsiders. Now, Lordship, so this Dr. Vihuto Asmi is representing Atoize area. And Atoize is situated under Zinyaboto district. And this resolution was passed at Zinyaboto. Here, the cause of action, I'm going to impress my Lordship on that point, where the cause of action. They have not mentioned, the opposite party has not even mentioned it. The jurisdiction issue is very crucial, and the Honorable Court, High Court, has sent it back to the lower court to educate the issue of jurisdiction in the first place, because the previous one did not interfere with, because that was the preliminary objection raised even in the IA 388. All the same, that was raised by filing a preliminary objection even in their IA written statement, in a form of written statement. The issue was raised, but the learned civil judge did not interfere with it. That is the reason why it has been sent back by this coordinate bench, has already sent back to the lower court to take up that issue first as a preliminary objection without going into the merit of the case. The case has not even started, Lordship, because these are crucial issues. Now, the Vice Presidential number 2 is Dr. Hoto Kuchishi, and that is from Puhoboto area, representing Puhoboto area, that is also under Zinyaboto district. General Secretary, Sri Hotosha Simi, Awomi, Suruhuto area, representative of Suruhuto area. 1. GB Ikuto Ke Yeptomi, Agnato area, representing Agnato. 2. Sri Hetoshe Jimomi, Sataka area. 3. Vikavi Asmi, Akulto area. 5. Finance Secretary, Sri Vikiho Arka, Zinyaboto, representing the Zinyaboto district. 6. Assistant Finance Secretary, GB Muravi Jimo, Suruhuto Asuto area. So these are the 6 representatives of the areas that the search committee thought and find them eligible to be elected as the office bearers of Sumi Ho Ho, with the present incumbent respondent number 2, Dr. Vihuto Asmi, as the president. It is their resolution, it is their selection. It has got nothing to do with any of the office bearers. This is the traditional practice, conventional practice, since the inception of Sumi Ho Ho in 1979. This has been the conventional practice, Lordship. Otherwise, there is nothing like election or
But there are some eligibility criteria.
yes, yes, I will come to that. I will come to that, Lordship. I'm going to come to that. And this, then my Lord will kindly see that the SD, the signatories are Shikaho Jimo, convener, President Western Sumi Ho Ho. I have already said that the autonomous body of the Western side Sumi. SD, Akukao Hetoho S Jimomi, President Simi Kakami Ho Ho, the village chief, president of the village chiefs, Viho Shemur, chairman Simi Literature Board, Simi Dialect Board. SD, Waiki Keto Sema, IAS, General Secretary, Simi Officers Union Nagaland. Hekishe Shiku, advisor Simi Ho Ho, the previous incumbent Lordship. Vitoli Rochil, President Simi Totimi Ho Ho, Simi Mothers Association Lordship. Then SD, Gihuka Kiejimo, President Simi Kipimi Kakulu. That is the 7 frontal organization who elected the respondent number 2 to be the president of Simi Ho Ho on 20. And after that, Lordship, I will just go by the Constitution of Simi Ho Ho. Then Article 713, Lordship.
Yes.
713 is 713, page 25, Lordship.
Yes, office bearer shall be.
Yeah, the office bearers shall be selected, inducted from amongst the executive committee members. This is the provision of the Constitution, Lordship. That is it. Then Article 14(1). Yesterday, my Lord Chief was questioning this. 14(1) says the Simi Ho Ho shall have a 49-member executive committee. Then, my Lord, this is the crucial one. I am on this, and this is from the first instance. This is my preliminary objection. Lordship, Article 16(6). I raise my case on this, Lordship. From the beginning itself, in my preliminary objection before the learned district and session, even before the district and session judge, as well as the learned civil judge. 16(6). Lordship.
Yes.
In the event any dispute that arises in this constitution, the decision of the executive committee shall be final and binding. I raise my case on this, Lordship, because in case if anybody does not feel aggrieved, complaint has to be filed before the executive committee in the first instance, alternative remedy. And the executive committee consisting of 49 members will take decision. So without availing this 16(6), they have straight away gone to
Civil court.
civil court. That is also everything. The decision was, the resolution was made at Zinheboto on 26/7/2024. There was a general body meeting of whole Simi public on 27. And on 27, the office bearers shall be selected by the search committee and present it before the general body meeting, and they shall approve. What is that? Lordship will kindly come to Article 7(3). Yes, Lordship. Just 1 minute. Reassurance. The office, 7-3 page 25, Lordship.
Yes.
I'm coming to that. The office bearers shall be selected by the search committee and shall be presented before the House for approval. My lord, this is clear?
Yes.
So on 25, the search committee consisting of 7 frontal organizations met a resolution and selected the office bearers on the second day. A general semi-public meeting was called for. That is in Sema dialect, Simi dialect, it is called Simi Bari Ho Ho. That is in the Bari Ho Ho. The new president, their names were read out, and all the Simi publics, more than thousands, Lordship. Whether you agree or not, that was practically.
They approved.
Yeah, and they approved on the 27th. They are challenging that oral declaration in their civil suit. In their civil suit. So on 27, the whole Simi, this is not an easy job, Lordship, to head more than 3 lakhs Simi population. So they are the one, the public raised their hand, and the selection of the office bearers of Sumi Ho Ho, including the respondent number 2. It was approved by the whole Simi public. Now coming here, Lordship, starting from the civil suit plaint itself till before this honorable court. These 7 petitioners, they are claiming that we are representing the whole Simis. We are representing the whole Simis. But where is the authorization? Without authorization. And in fact, they are challenging the action of the whole 7 frontal organization, who are the president, who elected the respondent number 2. And they are just stating that without any proof and evidence that there were other 3 contestants. Since there was no election, even the learned civil judge has said that contested 4 other contested in her one of her orders. It is mentioned, but these are all made up, Lordship. As I have said that since the inception, 4 candidates. Where are the candidates? Where is the proof and evidence? That has to go before the trial court with a competent jurisdiction. Here I'm before this honorable court on preliminary issue is because I kill a person, or I committed a crime at Dimapur, and can I go to Zunheboto territorial jurisdiction and file a case there, Lordship? These are the pertinent issues. Can somebody...
I have some queries. Their submission is that though you represent a particular area,
Yes,
that is, you just read out,
yes,
Vihoto Asumi,
yes, Lordship.
Atoizu,
Yes, Lordship.
Atoizu.
Yes,
area.
Lordship.
Their submission is that CPC provides that where defendant resides, you can file suit there.
That's why.
Therefore, yesterday the submission was made that as the defendant resides in Dimapur.
No. That's why they are misleading from the lower court till here. They are that is in the open whole Simi population. Lordship, why should I lie before this honorable court? I don't mislead, Lordship. I don't mislead. The respondent number 2 is the proprietor of a government higher secondary school. That's why my lord will kindly come to page 98 of my. These are the factual. They have approached this honorable court with unclean hands. These are the manufactured submissions, Lordship. All the documents that is annexed by the petitioners as well as the respondent placing before this honorable court. It has to go to before the trial court for trial and to lead evidence to prove or disprove. That is another issue. Theirs and mine. So 98.
Okay, otherwise that issue is pending before the.
Yes, exactly, Lordship. Exactly. That issue is pending.
In this case, their main plea is that 710 is not followed. Your age is
47 age.
less than 50 years.
I'm coming to that. I'm coming to that. That's why here is Lordship. My Lordship will kindly come to page 124. Yesterday I have submitted before this honorable court, the office of Sumi Ho Ho is not an office of profit. That is one. Secondly, it comes under Article 371, and under Article 371, the tribal council has empowered, the state government has empowered all the 17 tribes to have their respective tribal bodies to exercise in their own customary laws, in their own tradition, Lordship. That is another thing. And under this tribal council empowerment, this Sumi Ho Ho constitution under the Tribal Council Act exists, Lordship. I hope that is clear. Now, this is the invitation celebrating 50 years of, that's why these are the dispute that has to be decided by the, trial court. That is what I'm saying. That has competent jurisdiction.
Okay, you are disputing that you are not 47, but you have crossed 50.
I have crossed 50. My mother's birth. I'll show you. That is my contention
No,
before
we
this.
are not going into that, but you have a point to make that you are not 47 as stated by.
In my schoolings. Yes, Lordship.
They were relying on some documents like.
Yes, yes, Lordship.
Like your.
That will have to go through the legal process, Lordship. Yes. And
So you are.
I am 50 years from the lower court till the high court. In my affidavit, I have sworn that I am 50 years, and that basing upon this, 124 is the invitation. That is, he celebrated his 50th birthday golden jubilee on June 29, 2024. Then, next year, 125, page 125, Lordship. And next year's I have just I have not wrapped it out because all these were included in the lower courts, my first appeal, but they did not annex. They have, I'll show my Lordship. So, 50th birthday celebration of Dr. V. Hutto. That is 29 June 2024 at 2:30 p.m. Venue Emmanuel Higher Secondary School. He is the proprietor. He permanently reside at Zneboto and have a school at Zneboto. And this is the program. 125 is the program. Then my Lord will kindly, all the frontal organization, all the Sumi elders, officers, were invited, Lordship. And 126 is the Lordship, the photographs. And the left side, the last second one is the Reverend Pastor of Zneboto Sumi Baptist Church. So prior to selection of the, and Lordship will kindly come to, I'll just, yes, Lordship, page 129. What I mean to say is that, Lordship, he having completed 50 years of age, the Sumi publics elected him. That is what I'm just, it's not to substantiate before this honorable court. Page 129, Lordship.
Please come this. Come back. Yesterday's Yes,
103.
so this issue of age is also disputed by.
Yes, this is the only disputed issue.
Okay.
Plus, they are saying that I have served more than 2 years, more than 2 tenures, right? These are the two issues. It is only under challenge. Now, Lordship, reason best known, and Lordship will kindly just a perusal, 130 page 131. I'll just impress my Lordship. The acceptance will be later on when we go for trial, leading evidence. However, page 101, Lordship, my Lord has got it. 131. The original 131. Type copy is at 133.
Yes, I think this.
But just I want to show my Lordship in the original. Serial number 25. 131, serial number 25. Or the typed copy, Lordship.
Serial numbers are not legible
Serial number 25,
because that column has been torn off.
131.
That last left-hand column, where serial numbers are mentioned. What is the
Oh,
name?
yes, Lordship. Just, my Lord will kindly come back to 131. It's just a type out. However, in the original, it's very clear handwriting. This is 1973-74 birth register of Atoizu Semi Baptist Church, where the church always registered the birth of children. And this is from 1973 to 73, starting from 1973, when the respondent number 2, father, was the pastor of Atoizu Baptist Church. The respondent number 2 was born on 29 June 1974. So at serial number 25, there are all other 1974 born recorded. And at serial number 25, my Lord has got it. Serial number 25, page 131, in original handwriting, extracted from the church register.
What is the name?
Keto Luvi pastor is the father.
Father's name. K. Toluvi pastor.
Yes, Hashili is the mother. As mother's name at column 2. Column 3 is 29th 1974. 29 June 1974.
Where is June? 29/6, yes.
Yes. Then born 5 a.m. Then child's name Vihuto. My Lord has got it. Then 4/10/1974 is the date when they registered the child's name by submitting 10 rupees as a registration of name in the church. So that will suffice, Lordship. Just my humble submission, Lordship. As I have said, that it will have to go through a competent court for trial to prove and disprove. That is another issue. Whether their document or my document, that is the civil suit. Anyways, Lordship, I just want to impress my Lordship. I submitted all this in the lower court in my first appeal, but they did not annex any of the documents. Now, Lordship will kindly come to page 102. Receipt. After they filed the case, office of the Sumi Ho Ho is at Zinheboto town, Zinheboto district. Here comes the jurisdiction, Lordship.
I'm not arguing before this honorable court all this aspect, but yesterday they have argued before this honorable court as if the case is already been decreed. So just a slide to impress my lordship that this is how respondent number two.
What is this? 102?
This is Dr. V. Huto asked me. They sent through the post office. They have filed civil suit at Dimapur, saying that I am a resident of Dimapur by manufacturing a document from the GP. These are the lower court that will go to trial. But even there, this service notice, since I live at Zinheboto, Dr. V. Huto asked me, President Sumi Ho Ho, proprietor of Emmanuel Higher Secondary School, Project Colonies Neboto, pin code 798620, phone number so and so. Now, Lordship, at the last from Advocate Chamber near DC Court, Dimapur, Nagaland, pin code so and so, phone number so and so. Lordship, these things, since I have a plot of land. They even went up to the extent of filing an RTI and bringing that pata, just a plot of land at Dimapur, and placing all those things saying that I am a resident in order to file before the Dimapur district. Dimapur district, as I have said, I cannot kill somebody at Dimapur and go file a case at Zinheboto. Sumi Ho Ho is at Zinheboto. Office headquarters is at Zinheboto. All the elections are done at Zinheboto. The respondent number 2 is a permanent resident. My lord will kindly come. I have annexed his residential certificate. Permanent residential certificate is page 98. I have not annexed any of these documents in the lower court till date, because what has happened is preliminary objection stating that the trial court lacks jurisdiction to take up this issue. And there is an appropriate forum. So my preliminary objection to the lower court, including amongst other inter alia, that they have an alternative remedy under 16.6. Under 16.6, they have to file a representation before the executive committee, only availing that the final decision of the executive committee shall be final and binding is the provision of the Sumi Ho Ho Constitution, under which they approach the learned civil court. So if they are coming before this honorable court under the Sumi Ho Ho Constitution, they themselves has to abide by the Constitution in the first place. And why should everything happen at Sumi Ho Ho on 27 was held at Zinheboto. Selection was done at Zinheboto. Headquarters is at Zinheboto. The respondent number 2 is a permanent resident of Zinheboto at page 98, my lord.
In your written objection, which was filed before the trial court
Lordship.
in 488, 388.
388. Yeah.
Have you stated there that you don't reside?
Yes. All this.
You have stated everything.
Oh, of course, Lordship.
You have,
Then,
you have stated about your age also.
yes, Lordship, 50 years.
50 years.
50 years.
And you are not a resident of Dimapur.
Bamun Pukri. Bamun Pukri also I heard for the first time, even me myself. I didn't know that there is a Bamun Pukri colony at Dimapur. That was the first thing. So my permanent residence is at Annexure 98. I stated this. And my lord will also kindly, I'm again want to impress my lord that just 1 minute, lordship. Date of birth. Yes, that is the, everything was stated, and that is the preliminary objection. And in preliminary objection, lordship, preliminary objection has to be decided first instead of going into the merit of the case, so that, because as I'm saying before this honorable court, even if they want, they have an alternative remedy under the constitution, they approach this honorable court. That is one. Still, my preliminary objection or that they don't have apart from they not having a locus standi. Why I'm against, they even don't have a locus standi. Why I'm saying this? They are bona fide members of Sumi tribe, me too. But a civil suit is filed, praying before the honorable court to give me this personal relief. My own personal relief, civil suit are filed. Now here what has happened is, these 7 petitioners, they are saying, direct the Sumi Ho Ho to conduct a new, to elect a new president of Sumi Ho Ho. They are the third person. When I say that they are in law, these are called third party strangers in law, because they are not seeking their own personal relief. Can anybody, only in PIL, Lordship, one can file a PIL in the interest of all public. That is one. Civil suit is not a PIL. Just Lordship will kindly come to there. I have annexed their writ petition, their prayer. CS, page 21. I'll just show my Lordship.
No, yesterday their submission was, I misplaced the notes actually. The submission was, since the petitioners are members of Sumi Ho Ho, and since the
That is
Sumi
your-
Ho Sumi
that
Ho Ho
is
is
their
the
claim.
apex body,
That is still clear.
if there is a violation of
No,
constitution
no, no.
of Sumi
They
Ho,
are saying, Lordship, my humble submission before this honorable court is, they are claiming that they were 4 contestants including the present respondent number 2. Now, as legally, they are not interested party to be the president of Sumi Ho Ho. They don't have a locus standi. They are not even a member of to be elected as the office bearers of Sumi Ho Ho. Where is their locus standi? I am a bona fide.
no, but they, yesterday a provision was shown that each member of Simi community is a,
Member. Yes. I being a member doesn't mean, no, here Lordship will, if my Lordship will kindly appreciate that, I am also a member. A civil suit is filed for personal relief. Do this, quash his selection and appoint me as president. That is what we call individual relief, personal relief. They are pleading before this, in the civil suit, direct the Sumi Ho Ho. A civil suit is filed for personal relief, personal grievances, to seek personal right, a civil suit. So they not admitting, but even presuming, they don't have the criteria, but let the respondent number 2 be kicked out from the post of Sumi Ho Ho office. And since I'm eligible, I have the criteria. Appoint me to be the president of Sumi Ho. That is how a civil suit is filed. That's why I am raising this preliminary objection in the lower court is, this is not a PIL. Civil suit is not a PIL. How can they plead before a civil court to direct the Sumi Ho Ho to conduct election and to appoint unknown person without any name?
so one of the submission is that as they were not the contestant for the post of the president or any of.
No, yes.
Therefore, they lacks locus standi.
Yes, that is my prayer, and that is my preliminary objection before this honorable court, as well as the jurisdiction. Now this honorable court has sent it back to take up the issue of jurisdiction. So even just on the face of record, Lordship, if my Lord will kindly turn to Page 40, Lordship. Just
Yes.
one has to approach the court with clean hand, Lordship. I have a plot of land at Dimapur and they're saying that I am in the residence of Dimapur and they have filed a case, as I have said, commit something, some crime at Dimapur and go and file crossing to district and go to Zinapoto and file a case. No, Lordship, it is apparent on the first phase of record. These are the things that is from the beginning itself. That's why we have not entered into the civil suit yet. And on preliminary objection, there is alternative remedy. Let them approach the appropriate court. That is my still pending Lordship. In this, my lord will kindly, wait 1 minute, come to.
No, for preferring a civil suit, if otherwise your rights are violated, then the principle that you should avail an alternative remedy, it may not be applicable for filing a civil suit, like that of a writ petition.
And they did not even attend that Sumi Ho Ho. They are not even present on that day at Zinapoto. They are not contestant. They are not eligible. One thing, I will just take my lordship to 161. Whether that is eligible or not eligible, with or without that, I'm just impressing my lordship on the fact of the case, factual position. Now, why this in MAF 1124? Order passed on 3/12/2024. My lord, before this honorable court.
Page number?
Page number 118.
Yes.
My lord has seen it. This one, I filed this a miscellaneous first appeal before this honorable court, praying for quashing the impugn order of the learned civil judge in this MAF. Now, along with this, I filed civil revision 19/2024. That is for quashing the entire civil suit. These are the two at the same time I filed. What has happened is, my lord will kindly come. Even this honorable court, the High Court, this honorable court has stated
This.
Yes. My lord will kindly come to paragraph 2,
Yes.
page 118.
Yes.
I will just impress my lordship. 2, this is an appeal filed under the provisions of Order 39 Rule 1 of the Code of Civil Procedure 908 for short, the code, challenging the order dated 18/11/2024 passed by the Court of the Learned Civil Judge, Senior Division, Dimapur, in interlocutory application number 388/2024 arising out of civil suit number 23/2024. 3, it is noticed that against an order passed under Order 39 Rule 1 and 2 of the Code, the first appellate forum is the Court of the District Judge. Under such circumstances, it is the opinion of this court that this court does not have the jurisdiction to take up the instant appeal and is a fit case, therefore, to return of the appeal to the lower court, lordship. That is taking into account this, I will not read out. But even this honorable court, when I straight away came to the High Court, lordship, in Nagaland court, central laws that is applied in Nagaland are all listed out in the Nagaland court. So within my limited knowledge, lordship, I thought since the Civil Code Act of Assam, Agra, and West Bengal, does not figure in that code, I thought that it will straight away come to the High Court and file this MAF praying for quashing of the impugned order dated 18/11/2028. However, when the matter came up before the learned judge, single judge, he said that I have no jurisdiction to take up the instant appeal as it is a fit case, therefore to return to the appeal. And it was pronounced in the open court and revision. When appeal and revision in a civil suit arising out of the same case is before the learned court, appeal has to be heard first, appeal provision. Otherwise, there will be procedural discrepancies. So that's why he did not, the learned judge did not interfere in the impugned order and send it back for the respondents to approach the learned civil court. And under that, we approached the learned civil court and the interim order was vacated. Now, Lordship, since an appeal has to be filed before the learned single judge, the learned single judge,
Civil judge.
civil judge, the learned single judge of this honorable court stated that since first appeal is still pending, revision cannot overtake the appeal. That's why, though I may want to interfere, since you have to first file the appeal first before the, so the learned single judge sent back by passing the order. My lord will kindly, it's better to read out, Lordship. Though yesterday the learned
Which revision?
yes, revision.
Where is the order?
The operative revision is 122. So this revision 19/2024. That's why he could not interfere with the learned district and session judge order, because there lies the appeal. That's why this revision was also closed. Both the closed and it was sent back because he cannot interfere until unless that first appeal, as per law, has to approach the district and session judge. That was the intention of this honorable court. And now yesterday the learned petitioners were submitting before this honorable court. There was no interference. It was not quashed or something. But this is another issue. And this issue is not before this honorable court. And yesterday, the whole day, that civil revision 19, this order was submitted before this honorable, when this order was not even before this honorable court. Now it is very clear, Lordship, before this honorable court is only 388 impugned order granting temporary injunction to the petitioners in favor of the petitioner. And that also in violation of law specifically. I'll come to that. I have the citation. I'm coming to the law, Lordship. I'm just wanting to impress my Lordship. So 122.
Against 388, MAF 23 of 24.
Yes. So that is the only subject matter before this honorable court. Yesterday, the whole day, the submission was against 455. And this confusion, the confusion that was created yesterday, as if this is also before this honorable court. That's why at one point of time, I also wanted to jump up and clarify that, because what is the use of spending the time?
The submission was as while granting injunction in 488. Same court also dealt with the issue of maintainability.
Yes.
So it was within the knowledge of the said court that.
Of course.
Therefore, it was not discussed in 488.
488, no. 388, 388, yes. However, the 388, only this honorable court jurisdiction is that under 1115. So Lordship will kindly allow me to kindly read out 122. This is an application filed under section 115 of the Code of Civil Procedure 1908 for short, the code, challenging the order dated 18/11/2024, whereby the application so filed by the petitioner under order 7 Rule 11 of the code of the for rejection of the plaint was rejected. 3. Ms. Z. Jumomi, the learned counsel appearing on behalf of the petitioners, submitted that taking into account the purview of the provision of Order 7 Rule 11 of the Code, the petitioner would not like to praise the instant revision application. Rather, the issues which have been raised would be raised before the learned trial court in the form of preliminary issue, so that the same can be adjudicated upon in terms of Order 14, Rule 2 of the Code. 4. This court has duly heard the learned counsels appearing on behalf of the parties, taking into account the submission made by the learned counsel for the petitioners. This court does not closes the instant civil revision application. 5. The closing of the instant civil revision application shall not constitute as a bar to the petitioners who are the defendants in the suit to raise preliminary issues to the maintainability of the suit. This court further observes that the learned trial court shall decide such preliminary issue without being influenced by the order dated 18/11/2024, passed in IS Civil number 455/2024, arising out of Civil Suit 2023, number 23/2024. It is further ordered that if preliminary issues are raised, the same shall be decided in accordance with law. So why this was sent back and this has been passed by this honorable court is that legally, the preliminary objection has to overcome first, then the trial will, whether it will go to trial or not will depend upon the first, on the question of jurisdiction, inter alia, other objection that has been raised in the preliminary issue. I raised around 7 preliminary issues in all the written statement replied, even in 388 Lordship. So these are the factual position. Now, the matter is pending before the trial court for preliminary issue. We have filed as per this liberty. We have filed on 12/12/2024 and pending before the learned trial court for raising preliminary issue. That is for 459. So 559. 589, yes. So
But I will go into this, but my view is that I'm not making my final observations.
Of course,
Just
yes,
a passing observations
Lordship.
that you can, the scheme of CPC is that any objection you have to raise in WS only. And court may choose if it finds that some issues may be decided as preliminary issues, then it has to be decided first. Then
Yes.
there may not be necessity of deciding other issues. But putting a halt on the trial and filing interlocutory application, because your interlocutory application, deciding interlocutory application will take time. You have raised disputed questions of fact. You are challenging you have your own, you have raised contentions as regards age also. So you may have a case to prove, but for that evidence have to be adduced.
That is the issue.
So that can be done only in main trial.
Exactly.
Lordship, that will be another issue for the trial court, as my Lordship has already observed. That will depend upon the learned trial court. Now, me coming only on the issue of 388 and the impugn order of temporary injunction. Because of that only, we are before this honorable court.
Yes.
Lordship will kindly come
388
to,
and MAF 23/24.
yes. So what I mean,
Miscellaneous first appeal is numbered as 2.
One appeal for MF, one appeal for 2024. And Miss.
24.
1.
Yes.
yes,
Against the order passed in that miscellaneous first appeal, this
388.
revision is.
My lord, here is it, first appeal 2 before this honorable court, not miscellaneous. First
Hmm.
appeal,
First appeal,
First appeal 2.
yes.
yes, Lordship. So we are only on that, leaving aside 488, and that has been sent back to the lower court, Lordship, for fresh, raising fresh preliminary objection.
Actually, my notes are misplaced. Yesterday I took notes. The 38 against the injunction order passed in 388, you preferred
No, I preferred an appeal,
an appeal.
appeal before the
MAF
learned
one.
district and session judge.
MAF 1.
Yes.
Against MAF 1, which vacated the injunction order,
Ye-
this
No.
revision has been preferred.
No, Lordship.
No, lordship. Lordship, if necessary, I'll give the facts.
No, I have it. I have it.
You also give a brief in note form,
Lordship,
whatever you have submitted,
lordship,
gist of your argument.
lordship, lordship.
If I can locate my notes, then it may not be necessary.
Lordship,
But if I fail to locate it,
lordship.
Lordship,
There. It is there.
we have not yet found.
It is there. There.
Okay, so 388, then MAF 1.
In-
Impugn order was passed in?
388.
No. Against 388, you preferred a
Appeal,
appeal.
first appeal before the learned
judge-
district and session
district
judge.
That was registered as?
MA, that was first appeal first appeal number 2 of 2024,
And then impugn order was passed on
2012, 2024,
and 14/1/25.
yes, followed by,
In MAF 2 of 2024.
yes, Lordship,
FA 2 of 2024.
24.
Against that, this revision. So here you are against the order of granting temporary injunction.
Yes,
Okay.
they are before this honorable court
Yes,
against granting of the.
vacating of the,
Yes, vacating. So now I will just come to the main.
and their main plea was that the first appellate court vacated mainly on the ground of
Maintainability, issue of
that
jurisdiction.
that
I will
the
read out. I
trial
will
court
read
did
out.
not decide the issue of maintainability.
Yes, because the
While
lower,
That was the ground.
that is the ground. So now Lordship will kindly come. Under what circumstances temporary injunction are granted by the honorable courts? Order 39 rule 1.
Yes.
I will rely my cases only on the law.
Yes.
Whether granting a temporary injunction in favor of the petitioners in this case falls under this one. My lord has got it.
Yes.
Order 39, rule 2. Cases in which temporary injunction may be granted.
Yes.
Lordship, to cite Supreme Court cases or other cases also that will be undermining the intelligence and the judicious mind of this honorable court, because the CPC is very clear as to why the learned civil judge perversely passed that order suspending the respondent number 2. This is the only issue before this honorable court by both the parties, nothing else. So now I will rely on the provisions of law. Cases in which temporary injunction may be granted, where in any suit it is provided by affidavit or otherwise. A, that any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit, or wrongfully sold in execution of a decree. Or B, that the defendant threatens or intends to remove or dispose of his property with a view to defrauding his creditors. C, that the defendant threatens to disposes the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit.
Yes.
The court may, by order, grant a temporary injunction to restrain such act or make such other order for the purpose of staying and preventing the wasting, damaging, alienation, sale, removal, or disposition of property for disposition of the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit, as the court thinks fit until the disposal of the suit or until further orders.
Yes.
So, do the granting of interim injunction to the petitioner fall under these three? Lordship, each fact and circumstances differ. These are temporary injunctions are granted mostly in matters of property, in contract, or any other such. Where is the question of suspending? The civil judge does not even have a jurisdiction.
So
Power and
order 39 rule 1 is not applicable.
yes, not applicable. And this is the golden principle of granting interim order.
Order 39 rule 2.
Rule 2. Injunction to restrain repetition of continuance of breach. Lordship, what has happened is, since my lord has already pointed this out, I will satisfy my lordship. My lordship will kindly come to page 142 of my affidavit in opposition. A temporary injunction perversely granted, how it affected the whole Sumi population. I will satisfy my lordship.
140.
Page 142 of my affidavit in opposition. After reserving order for a month or so, suddenly, out of blue, the president of Sumi Ho Ho was suspended, though under the provisions of law. This issue doesn't fall under these principles. Now what has happened? Suddenly, this 42 is all this, the learned civil judge and the petitioner think, is this injury, irreparable injury causing to them? What are the injuries that is causing to the petitioners? This is Central Nagaland Tribes Council, that is CNTC. That is a coming together of 3 tribes, Aos, Semas, and Lothas. The order was passed on 18. So suddenly this was preponed program, Lordship. Dated 2011, the interim order was passed on 18/11/2020 24. Time 10 a.m. Venue Seden Riju Purana Bazar Dimapur. This is 3 tribes. Cultural Exchange Program 2024. Such a big program was to be held on 20th. Suddenly, after he was suspended, he had to cancel this. And Lordship will kindly come order of the program at the serial number 3. Greetings in the program. Ausen then Lotha Ho Ho, Sumi Ho Ho. He was to give greetings in the get together. Suddenly, out of nowhere, this was cancelled. Is this causing injury to the petitioners? My Lord has to application of mine, Lordship. This is very unfortunate. So this one was cancelled. Then 144. This is one program just because granting of this interim injunction perversely that does not fall under the law coming under this temporary injunction. How an erratic order has made the
I could not get it.
yes, Lordship.
This Central Nagaland Tribe Council meeting,
Yes.
some function was organized on
Yes.
2011. How it relates to this?
Respondent number 2. Respondent number 2. Respondent number 2 was to attend this program to give greetings
President,
as the president. Now, because of order passed, impugn order passed on 18/11/2022, suddenly this has to be cancelled.
why?
Cancelled because of the interim order.
No, because your constitution says that if president is unable to work, vice president will.
I will come to that, Lordship. I will come to that. I will come to that. I will impress my Lordship. Then the second is 145. Here also welcome greetings. This is church leaders of all Sumis that was also cancelled. Then this is Mishikito Kipimi Kakakulu, that is Studel Biennial Conference, where he has to be the chief guest as the president of Sumi Ho Ho at page 146. This was also cancelled. Then 49, Sumi Martyrs Day 2024. That was to be held on 28th, 2024. All this, and the 51 is at 150. Im Loto Students Union to be the chief guest as the president of Sumi Ho Ho. All these were cancelled. Now, Lordship, as per law, is cancelling. Lordship, let me come to my Lordship constitution, where my question, my Lordship was raising. As for the impugn order of the civil judge order. Lordship, I will, yes. Just the operative portion of the last order. I will read out, if my Lord will permit me, if I happen not to satisfy my Lordship, I will read out the orders. Otherwise, the last page.
Which page?
Page 116. The one I mark with the dash is the number. There are 2 numbers, but the other one is the number that I pasted in the appeal, which they did not included, which they did not annex in coming before the Honorable Court. So, Lordship, the order that was, the defendant opposite party number 2 is restrained from continuing to function as the president of the Sumi Ho Ho with immediate effect till the final disposal of the suit. Final disposal of the suit. Lordship has got it.
Yes.
Here, I will say that in the guise of interim injunction, it inadvertently amount to decreeing the entire suit at an interim stage, Lordship. Suspending this is the only issue before for filing the civil suit. Now, if the respondent number 2 is suspended, this is the only issue in the civil suit that it amounts to decreeing the entire civil suit at an interim stage where, if so to say, literally, the respondent number 1 and 2 has nothing more to agitate before the civil suit. Till the disposal of the suit. Lordship, this kind of interim order does not come here. It does not even fall under Section 39, Rule 1. Now, 2. So that is my challenge in the my preliminary objection. It is passing disposing of the entire civil suit literally. So what is there for the petitioner to agitate furthermore in the civil suit? When he is suspended for the whole, till the disposal, I will submit the authorities. They will drag on for, it's only for 3 years tenure, Lordship. 1 year already gone.
No, but that order has been vacated.
Yes, exactly, Lordship. But just, Lordship, then the present Vice President of Sumi Ho Ho shall henceforth assume the office of the President of the Sumi Ho Ho till the final disposal of the suit. This is not even prayed in the civil suit. A prayer which does not figure in the civil suit cannot be granted by the trial court. That is the proposition of law, Lordship. All this was not even read in the. Now, Lordship, how Vice President is to be. Lordship will kindly come to Article 917 of the Sumi Ho Ho Constitution. Article 917, Lordship. 97. That is page.
Yes, in the event of.
Page 26, huh? 26, Lordship. This is outside the purview. The learned single judge, the learned civil judge violated this direction. Article 97.
Yes.
97 says, Lordship, in the event of President's resignation or death, the elected Vice President take charge of the office till the tenure is completed. So, to take over the office of the president post, in the event the President resigns, the President resignation or death. So how can in violation of this?
95.
No, 97.
95, yes. Well, kindly read 95.
That is when the president goes on journey or somewhere, just within day to day.
So Constitution provides for contingencies.
Yes.
But in absence of president, who would be responsible for who would look after his responsibility, the Sumi Ho Ho Constitution provides for in different provisions, 95, 95 as well as in 97.
97.
But that is not the issue.
Yes, Your
Issue
Lordship.
is
Nevertheless,
388 was the grant of injunction in 388 was overturned by the First Appellate Court.
Yes, yes, Lordship.
Now, whether what is they are saying that order of the vacation of the temporary injunction is
Illegal.
illegal.
So where is the illegality, Lordship? When the learned district and session judge has vacated the order, now here, my lord, the opposite party will submit whatever they want. I will submit whatever they want. But I trust this judicial court that what has to be done and what has to be decided will be done by my lordship. So their submission and my submission is just before this honorable court to
So why the first appellate court order dated 2012-2024 and 14-1-2024 should not be interfered with?
Yes, I will come to that. Lordship, first, let me just complete my this specific relief act. I'm presenting before this honorable court only the legal provisions on Lordship. I'm not submitting anything outside the purview of the Sumi Ho Ho Constitution, outside the CPC, outside the specific relief act. These are the legal provisions, and then I will come to the authority of the Supreme Court.
You have 1 hour time,
Yes, Lordship.
maximum.
Lordship is just a short matter, but can't help it, Lordship, although we want to satisfy this honorable court because it involves a very large population, and this has affected the whole Sumi tribe, both ways. Lordship will kindly come to section 41, Specific Relief Act, 1963.
Yes, what it says?
This is injunction when refused. So we are only on that. But however, I want to satisfy my lordship that all these are interconnected. That's why I've been going round and round. However, my submission will limit to only Specific Relief Act, CPC, and the Sumi Ho Ho Constitution. And if my lordship, in fact, this kind of cases should not come before the civil court. That is just my personal, since this comes under the customary body, and since there is a provision, if they are coming before this honorable court under the Sumi Ho Ho Constitution, there is also a provision under 16(6), alternative remedy, lordship. And if this court observes that this is not necessary, then that will make the Sumi Ho Ho Constitution redundant, under which the opposite party has approached this honorable court. And within the local limits of a traditional body, overriding this, so appropriate forum, they can approach appropriate forum, lordship. So, section 41, lordship. Yes, my lord, got it?
Yes.
Injunction, when refused, an injunction cannot be granted. A, B, C, D, we are not concerned with that. E also not concerned with that. G, injunction. I'll come to G, lordship. My lord will kindly appreciate the Sumi Ho Ho Constitution 16(6) comes here. It is also a law, since it has already approached the civil court. They themselves have approached under the Sumi Ho Constitution, and it cannot be said that what they approach is the law. What is contained in 16(6), Article 16(6) cannot be enforced. It's not that. Law is applicable. And if this constitution of Sumi Ho Ho is applied, it should be applied in general. If not, they have violated it. H, when equally efficacious relief can certainly be obtained by any other usual mode of proceeding, except in case of breach of trust. That is one. So under this H, 16(6) Sumi Ho Ho Constitution is available. They did not avail and has come straight to the civil court under the Sumi Ho Ho Constitution. So they should also come through 16.6 because that is the authority lordship. Any dispute arising out of the constitution, the decision of the executive committee, 49 executive committee decision shall be final and binding. They have to go through that, lordship. That is my humble submission. If this honorable court is allowing them to approach this honorable court in the lower court as well as this honorable court, it is only under article Sumi Ho Ho. So this also, they have to first abide by the constitution under 16.6. That is my plea before the civil court as well as before this honorable court. I am trying to bring to the notice of my lordship. Then J says, when the plaintiff has no personal interest in the matter. When the plaintiff has no personal interest in the matter. None of the plaintiff has personal individual relief centered. What can the Sumi Ho Ho grant them? Lordship, they have to ask Sumi Ho Ho when they are bringing the opposite party to before the civil court, they have to seek relief from the opposite party. That is the intention of the civil suit. Now, Lordship will kindly approaching the civil court comes within the purview of compensatory, punitive damage, declaration of title, right, partition, damages, specific performance in contract, etc. So here, as I have already stated, they are seeking relief for unknown person to be appointed as the president. So that kind of pleading cannot stand before this honorable court. Now, just as a last option, Lordship, whether my lord will kindly see the last prayer, page 40 of my affidavit in opposition. They have not even disclosed the cause of action of the place because they know that everything took place, wholly arose, the cause of action wholly arose at Zimeboto. So they have not pleaded anywhere that the cause of action arose at Dimapur on so and so that. I think, Lordship, in your wisdom knows these are the pleadings of the civil suit. 12, page 40. Can this kind of a civil suit sustain? That's why we file for rejection of the plaintiff, because even on the apparent on the face of record, it is not maintainable. 12, paragraph 12, that the plaintiff therefore fervently prays for immediate indulgence by this honorable court in the interim to restrain the defendant number 2 from functioning as the president in the office of the Sumi Ho Ho, and thereafter remove him from his office for misconduct as president with a direction to reconduct a new proceeding for electing a new president in the office of the Sumi Ho Ho as per the constitution. Whether this kind of seeking direction is applicable, Lordship, when there is a constitution. 13, the cause of action, this is very relevant, Lordship. The cause of action arose on several occasions, as mentioned here below. Lordship, 1, when the defendant number 2 was appointed as General Secretary for the 3rd term for the year 2021 to 2024. So the cause of action, they said, arose in 2021. If we count from there, it is barred by limitation, Lordship. Where were they? This is something very haphazard. 2021 to 2024, where came this kind of cause of action when the defendant number was appointed General Secretary way back in 2021 for the 3rd term for the year 2021-2024? It cannot stand the scrutiny of the law. 2, When the defendant number 2 was nominated as the president on 26 July 2024 and is continuing day to day within the jurisdiction of this court. Where? Under Dimapur jurisdiction, where? He was elected at Zinepoto. See, this kind of lordship, this kind of haphazard prayer continue within the jurisdiction of this court in Dimapur. When everything is at Zinepoto, it will set bad precedent, lordship, in Nagaland. The local territorial jurisdiction issue. Everybody will start filing cases around the whole district of Nagaland. It will set bad precedent. 14, that the suit is filed with limitation of this honorable court is well within the jurisdiction to pass any orders. Where is the proof? Where do the honorable trial court at Dimapur has the jurisdiction? That the suit is filed bona fide and for the ends of justice, the plaintiff therefore prays for the following reliefs. Declaring result dated 26 July 2024 of defendant number 2 as president of Sumi Ho Ho as ab initio, unconstitutional, illegal, and null and void. They were not even present on that day. They are all resident of Dimapur, the petitioner, if we go by the legality. Now, 26 July, it was only a declaration in semi-general body meeting where 1,000 raised up their hands approving the election of the office bearers of Sumi Ho Ho.
Where the general body meeting was held?
Zinyaboto. Yes, everything, not even partial. The whole cause of action was wholly at Zinyaboto. That's why I am on jurisdiction of the court. And this honorable court, on seeing those factual position, has sent back to the trial court to raise preliminary objection and to settle
When the meeting was held?
2026.
26?
Yes. Resolution, the only documents,
26, which date? Month?
26 July 2024. And here,
And where the search committee gave its report?
at Zineboto on 25th July. 25th July, they passed a resolution and the next day it was placed before the general body meeting on 26th and the whole Simi raised up their hand to approve it. See, these are the circumstances, Lordship.
Where is
Then-
the office of?
Simi Ho, Zineboto. Everything at Zineboto, Lordship. That's why. Then, for direction restraining the respondent number 2 from continuing to function as the president of Sumi Ho Ho and disqualify him from the present position. If they want to say this, then appoint me. That should be the pleading. Then appoint us, any one of us, 7 of us. Because, oh, Lordship, we cannot plead in a civil suit, we cannot plead for other unknown person. For a direction to the office of Sumi Ho Ho to conduct a fresh and fair election. No election was ever held. Fair election for the post of president, ensuring full compliance with the Sumi Ho Ho Yezabo and or pass any other. So these are the prayer. Even in the prayer, the cause of action, they have never mentioned whether the in a civil suit, the cause of action arose at Dimapur on so and so that. That also they filed in Dimapur, they have not mentioned that because they cannot. Everything is wholly cause of action is at Zineboto. But they cannot plead that the cause of action arose at Zineboto because they are filing it at Dimapur. So these are the discrepancies and illegalities that has been committed, Lordship. So if the cause of action, they say that arose at 2021 till 2024. Now that also I have not make an issue that will be in the lower court, but that also That means since 2021, if we compute it, it is already barred by limitation. So these are the first cost title. Oh. Yes, when I say that they don't have a local standard, that is 713, I have already read out. My lord has taken knowledge of it. 713 of the Constitution, page 25.
What is 7?
So apart from the jurisdiction of the court. The office bearers shall be selected and inducted from amongst the executive committee members. So the plaintiffs, they do not have the locus standi, lordship. If so to say, not admitting, but even presuming, those who they are saying that contested, lordship, in your wisdom knows, they have to be the petitioners, if so to say. Impeach the respondent number 2. I have the criteria. Select me as the president. That should be the prayer. So the age of 50 years, I have already submitted in all my pleadings. I am already 50 years, basing upon my original date of birth by my mother. That will come later on, lordship. And so that is what I'm saying, that I'm already 50 years. And preliminary objection has been raised in the lower court. Preliminary objection issue is a legal argument raised in the beginning of the case that if accepted would stop the case from proceeding further, often challenging the court's jurisdiction or the admissibility of the case. Now, lordship, I will just come to the authority.
You also gave me a gist of your argument in 1 or 2 pages. Bullet points.
Yes. 2008, 12. Lordship was inquiring about the pleadings. This is of Jharkhand High Court, Coordinate Court. Para 4, second page, lordship. This is exactly the same position, lordship. On the basis of the pleadings, the defendant petitioner filed an application under Order 7, Rule 11, CPC praying for rejection of the plaint on the ground that it is barred by provisions of Legal Services Authority Act 1987. The court below, after hearing the parties, rejected the application on the ground that issue have not yet been settled in the suit, and therefore the point raised by the defendant petitioner shall be considered after framing of issues. 5. No, this is the pleading. There is differences between the provision of Order 7, Rule 11 and Order 14, Rule 2 CPC. That is where we have filed in the lower court the present IA, lordship. Under Order 14, Rule 2 CPC, a prayer may be made before the court for deciding any issue as preliminary issue, whereas under Order 7, Rule 11 CPC, the defendant may take a prayer for rejection of the plaint on the ground enumerated under Order 7, Rule 11 CPC. Hence, prima facie, I am I am of the view that the court will not wait for disposal of the application filed under Order 7 Rule 11 CPC till the framing of issues. On going through the plaint, particularly para 6, 10, 13, and 12, it appears that the court below has to consider the application and to pass order as to why the plaint be not liable to be rejected. The impugned order therefore cannot be sustained in law. This application is therefore allowed. An impugned order is set aside. The matter is remitted back to the lower court below to dispose of the application filed by the defendant petitioner under Order 7 Rule 11 CPC by a recent order. This is one. And what is another? Mark. Lordship has got it. This is SEC online. Madhya Pradesh 187. AIR 1992 MP 326. Para 19. I will just come to the operative portions only. Para 19. Apart from what has been stated above, relief of temporary injunction is an equitable one and is in the domain of the court's judicial discretion. Therefore, even where the three well-known concurrent conditions, prima facie case, balance of convenience, and irreparable injury, requisite for the grant of relief exist, the court, on the facts and in the circumstances of the case, in exercising its discretion judicially, may still refuse the relief, as where there has been delay and the party applying for the relief has not come with clean hands. I have stated before this honorable court that it's not as clean as it ought to be. Then, Lordship, 2012, 6 SCC 792. Lordship, the para is 26, starting from 26. 37. It's a short one, Lordship. 26. It has been held in this by this court in Kishore Singh, Ratan Singh, Jadeja versus Maruti Corporation that it is well established that while passing an interim order of injunction under Order 39(1) and 2 CPC, the court is required to consider whether there is a prima facie case in favor of the plaintiff, whether the balance of convenience is in favor of passing the order of injunction, and 3, whether the plaintiff will suffer irreparable injury if an order of injunction would not be passed as prayed for. So here, where does the petitioner, servant petitioner falls under this 3 golden principle, Lordship? Added by Order 39, Rule 1. They don't fall under this category. What irreparable injury? They are injuring the whole public, Sumi tribe. In fact, 30, paragraph 30, Lordship. In Dalpat Kumar versus Prahlad Singh, this court held, para 5, satisfaction that there is a prima facie case by itself is not sufficient to grant injunction. The court further has to satisfy that non-interference by the court will result in irreparable injury to the party seeking relief, and that there is no other remedy available. Lordship, 16, I hope my Lordship will remember 16.6. There is no other remedy available to the party except one to grant injunction and he needs protection from the consequences of apprehended injury or disposition, irreparable injury, however, does not mean that there must be no physical possibility of repairing the injury, but means only that the injury must be material one, namely, one cannot be adequately compensated by way of damages. 33. Despite this claim towards damage made by the respondent number 1, in the plaint, the trial court has held that if the temporary injunction as sought for is not granted, liberty agency may lease or sublease the suit, schedule property, or create third-party interests over the same. And in such an event, there will be multiplicity of proceedings, and therefore, respondent 1 will be put to hardship and mental agony, which cannot be compensated in terms of money. This also has been referred by the learned civil judge. Respondent 1 is a limited company carrying on business and ready-made garments and will fail to appreciate what mental agony and hardship it will suffer except financial losses. 34. The High Court has similarly held in the impugned judgment that if the premises is laid out, respondent 1 will be put to hardship and the relief claim will be frustrated, and therefore it is proper to grant injunction, and the trial court has rightly granted injunction restraining the partners of liberty agency from alienating, leasing, subleasing, or encumbering the property till the disposal of the suit. 35. The High Court lost sight of the fact that if the temporary injunction restrained liberty agencies and its partners from allowing, leasing, subleasing, or encumbering the suit, scheduled property was not granted, and respondent 1 ultimately succeeded in the suit, it would be entitled to damages claimed and proved before the court. In other words, respondent 1 will not suffer irreparable injury. 36. This is very interesting, Lordship. To quote the words of Alderson B. 36.
Yes.
Page, para 36. To quote the words of Anderson B. in Attorney General versus Hallett, I take the meaning of irreparable injury to be that which, if not prevented by injunction, cannot be afterwards compensated by any decree which the court can pronounce in the result of the cause. For the aforesaid reason, we set aside the order of temporary injunction passed by the trial court, as well as the impugned judgment and the order dated 16/7/2010 of the High Court. The appeals are allowed with no order and post. This is then 1998 SCC online. Just a short one. This is 1992. This is 1992, one Supreme Court, 719 Lordship. Paragraph 4 and 5 only.
Page number 7,
Uh,
719.
yes, page number 719.
Yes.
Order 39, 1C provides that temporary injunction may be granted where in any suit it is proven by the affidavit or otherwise that the defendant threatens to dispose the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit. The court may by order grant a temporary injunction to restrain such act or make such other order for the purpose of staying and preventing or disposition of the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit as the court thinks fit until the disposal of the suit or until further orders. Pursuant to the recommendation of the Law Commission, Clause C was brought on statute by Section 86, 1B of the Amending Act 104 of 1976 with effect from February 1, 1977. Earlier, thereto, there was no express power except inherent power under Section 151 CPC to grant an ad interim injunction against dispossession. Rule 1 primarily concerned with the preservation of the property in dispute till legal rights are adjudicated. Injunction is judicial process by which a party is required to do or to refrain from doing any particular act. It is the nature of preventive relief to a litigant to prevent future possible injury. In other words, the court on exercise of the power of granting ad interim injunction is to preserve the subject matter, Lordship, this is very important, of the suit in the status quo for the time being. It is settled law that grant of injunction is discretionary relief. The exercise thereof is subject to the court satisfying that there is serious disputed question to be tried in the suit and that an act on the facts before the court, there is probability of his being entitled to the relief asked for by the plaintiff defendants. 2. The court's interference is necessary to protect the party from the species of injury. In other words, irreparable injury or damage would ensure before the legal right will be established at trial. And 3, that the comparative hardship or mischief or inconvenience which is likely to occur from withholding the injunction will be greater than that would be like to arise from granting it. 5. Therefore, the burden is on the plaintiff by evidence alleged by affidavit or otherwise that there is a prima facie case in favor which needs adjudication at the trial. The existence of prima facie right and infraction of the enjoyment of his property or the right is a condition, very important, Lordship, is a condition for grant of temporary injunction. Prima facie case is not to be confused with prima facie title, which has to be established on evidence at the trial. Only prima facie case is a substantial question raised bona fide, which needs investigation and a decision on merits. Satisfaction that there is a prima facie case by itself is not sufficient to grant injunction. The court further has to satisfy that non-interference by the court would result in irreparable injury to the party seeking relief and that there is no other remedy available, Lordship. There is no other remedy available to the party except one grant injunction, and he needs protection from the consequences of apprehended injury or disposition. Irreparable injury, however, does not mean that there must be no physical possibility or repairing the injury, but means only that the injury must be a material one, namely one that cannot be adequately compensated by way of damages. The third condition also is that the balance of convenience must be in favor of the granting injunction. The court, while granting or refusing to grant injunction, should exercise sound judicial discretion to find the amount of substantial mischief or injury which is likely to be caused to the parties if the injunction is refused, and compare it with that which is likely to be caused to the other side if the injunction is granted. If on weighting competing possibilities or probabilities of likelihood of injury, and if the court consider that pending the suit, the subject matter should be maintained in status quo, an injunction would be issued. Thus, the court has to exercise its sound judicial discretion in granting or refusing the relief of ad interim injunction pending the suit. 2015. 7 SCC. 2015 7 SCC 321 Lordship. 321, 18, 19, 20 paragraph. My lord has got it. Page 325, paragraph 18. Paragraph 18. Should I read out, Lordship? Thus, with the intention to put the aforesaid practice to test, the state legislature introduced Section 9A by the Amendment Act of 1969, requiring the court to decide the issue of jurisdiction at the time of granting or vacating the interim relief. In other words, the legislature inserted Section 9A to ensure that a suit which is not maintainable for want of jurisdiction of the court concerned ought not be tried on merit without first determining the question of maintainability of the suit as to jurisdiction of the court approached by the plaintiff as a preliminary
No,
issue.
but 9A is not applicable here. It is
Lordship.
state amendment of Maharashtra. Yes. This may not be applicable
To us,
to us.
Lordship. However, but principle applies in general. If that is to be taken off, that is okay. 19, Lordship, 19,
Okay.
paragraph 19. That is only with regard to 9A.
19,
Yes.
it says,
19 says, the provision contemplates that when an issue, page 326, Lordship. The provision contemplates that when an issue of jurisdiction is raised, the said issue should be decided at first as expeditiously as possible and not be adjourned to later date. The primary reason is that if the court comes to finding that it does not have jurisdiction vested in it in law, then no further inquiry is needed and save a lot of valuable judicial time. 20. A perusal of the I will just submit only that. Anyway, Lordship, a perusal of the statement of object and reason of the amendment act will clarify that.
no, this we don't require.
Okay,
Because
9A. Then 2002-10 SCC 101, Lordship. Only paragraph 3, Lordship. Which paragraph 3?
Yes.
Heard the counsel for the parties. We are of the view that the question regarding the jurisdiction of the court was required to be decided as a preliminary issue. We therefore set aside the order under challenge and send the case back to the High Court to decide the question of jurisdiction of the court as a preliminary issue. The order passed by the High Court directing the defendant appellants to furnish security for a sum of rupees 55 lakhs by way of bank guarantee shall remain suspended till the said question pertaining to the jurisdiction of the court is decided by the High Court. In case it is held by the High Court that the court has jurisdiction, the direction to furnish security for a sum of rupees 55 lakhs shall come into operation. This appeal is disposed of. Lordship,
No, there is no dispute that the preliminary issue has to be decided.
yes,
first.
exactly, Lordship. So my coming around all this thing comes to at the end of the day comes to the conclusion that the learned district and session judge vacating the interim order, impugned interim order dated 18/11/2024 should not be interfered because it does not fall under Order 39, Rule 1. That is very specific. Mostly it comes within the purview of property disputes, and as I have already mentioned, Lordship, and in no way it comes to office on the issue of office dispute, Lordship. So my Lord will kindly appreciate that this is day-to-day's work. The Sumi tribe in general, Lordship, is in coma because of this case has affected the whole tribe, and servant petitioner, as I have already, it's not before this honorable court, but their legal status to appear before the court is also under preliminary issue, as well as the jurisdiction. That is very clear, Lordship. That I don't know what.
One query from you.
Lordship.
What right of yours has been violated?
Yes, I will come to that. Definitely.
No, only you, I have heard you at length.
My lord, the point is this. The point is this.
The only ground was that every
No, no.
Sumi member is affiliated
Yes,
to Sumi Ho.
Hold on. Every Sumi is a bona fide member of the Sumi Ho Ho. So, my lord, I have a right to ensure that the constitution is preserved and the Sumi Ho functions strictly in accordance with the provision of the constitution. Is it that my right as a bona fide member that the apex tribal body of my tribe should function strictly in accordance with the provision of the constitution which has been given to us? I'm coming to that point, Lordship.
Just one clarification, Lordship, with due respect.
Please,
sir.
please.
One clarification. Again, also the preliminary issue pending before the learned trial court is that the seven frontal organization, as I will read out, Lordship, were the search committee, and they were the one whose action they have come before this honorable court, and by whose action selecting the respondent number 2 and office bearers for the tenure.
Non-joinder issue you have taken.
Yeah.
Non-joinder.
Non-joinder of party, that is not fatal, but non-joinder of necessary party. They were not even made a party, and they are coming before this honorable court basing on the strength of that. That is also the fatal question.
No, what right?
Lordship.
And what relief you are seeking
Yes.
for yourself?
My lord, Lordship, I'm coming to that. Let me give a preposition. It will never happen in India, but let me give a preposition. Suppose tomorrow, the Electoral College for the President of India select a person who is below the prescribed age. My lord, the people of India has given the constitution to ourselves. So tomorrow, if the Electoral College for election to the post of president elect a person.
But for that, you have to be in the voter list.
My lord, that is the
Here-
point. So
Here
that-
the
that is the-
election, here the
So, my
selection
lord,
is made by executive members only.
well, selection is
among
made,
from-
but the point I'm making, Lordship, the point I'm making is that in terms of the constitution, I'm a bona fide, every bona fide member, every Sumi, bona fide Sumi is the member of the Sumi Ho.
No, the language is.
Lordship, kindly allow me,
he
kindly allow me.
Affiliated to Sumi.
Lordship, kindly allow me, kindly allow me. I'll show you.
Not,
My lord,
he is affiliated to Sumi Ho Ho. Every member.
no, my lord, kindly allow me.
Exactly. That is-
My lord, I'm going to the constitution just to show that.
I have even pleaded that they are bona fide members of Sinho all my pleadings. That is
Huh?
all Sinhis are bona fide.
No,
But that doesn't
in
mean
his-
that
in
each
his
and everyone
constitution.
has to go against the
Huh?
constitutional
Lordship,
provision.
in my affidavit, in my appeal. In my appeal. Huh? Page 54, Lordship. 1.3.
$54.
1.3.
Yes.
Every Sumi individual shall be a member of the Sumi Ho. So, my lord, as you have rightly pointed out,
So,
if somebody should, your lordship, to my proposition, your lordship was replying that, then somebody should be in the voters list. Now, my lord, tomorrow, the electoral college for the president is the MLS in member of parliament in the legislative assembly. They elect the president of India for an electoral college. Tomorrow, lordship, in violation of the constitution, where the minimum prescribed age is provided for election to the post of president. If somebody, God forbid, and only it's a proposition, if tomorrow somebody is elected underage, then whether or not the citizens of India have a right to challenge the issue. Similarly, lordship, here,
they may have a right to challenge.
so my
But
lord,
whether by filing a civil suit
yes,
or under
my lord,
226.
then lordship will kindly come. Lordship will kindly come to the Lordship may kindly come to the constitution. Since my learned friend has been using his constitution, page 22, the affidavit in opposition on my learned friend, just refer to the constitution. Sumi constitution. 4.7. Affidavit in opposition, lordship. Affidavit in opposition, page 29. Let me go by the constitution annexed by her.
Which,
Page 29,
yes,
4.7. The Sumi Ho Ho is not a statutory body, but at the request of the disputing parties. Huh?
4.7, it is at
Page 23, lordship.
23.
It is, two pages are mentioned on the top. That's why, my lord, it is 23. 4.7, lordship. The Sumi Ho Ho is not a statutory body, but at the request of the disputing parties. Sumi Ho Ho shall intervene in the disputes and settle conflict resolution. This is one. Then lordship may kindly see 16.6 at 29.
Yes.
Which book? In the event any dispute that arises in this constitution, the decision of the executive shall be final and binding. It is only talking about, lordship, dispute within the constitution. So, my lord, my respectful submission.
No,
My lord, this is the point. My lord, I'm coming to that.
I'm not coming to a finding.
My lord, I have in the lower court below, when the IA was filed, and as well as in the civil suit, because that would not be subject to this. It has been categorically stated that we have approached the authority, the Sumi authority, after we came to know about the discrepancies in the age. But since there was no positive action, rather, Lordship, I was expelled. Petitioner number 2 was expelled. I'll show the record for protesting against the authority of the authority. Ho Ho. That's how, Lordship, I came before the General Board. And in my respectful submission, Lordship, availability of alternative remedy is not there in the Constitution, and even presuming and not admitting that it is there, even presuming and not admitting that the alternative remedy is available in the Constitution, it is not a bar for the petitioners to approach civil court. And that issue will come in the appropriate forum. Because, my lord, that has already been decided. As on today, that is what I was submitting the other day. On preliminary issues in 455. Because jurisdiction, local standing, everything has, Lordship, subject to repetition. I will, my lord, I will only give pointed replies to my learned friend's submission. But yesterday, twice I was submitting before this honorable court that on the issue of local standing, on the issue of jurisdiction, on the issue of cause of action, on the issue of alternative remedy, and Lordship, and on all these issues, Lordship, that has been decided in 455. And that has not been interfered by this honorable court. Nor it was the prayer of the petitioner, respondent, for modification interference. Her only prayer was that kindly allow us to raise preliminary issues, raise it as a preliminary issues in the trial court. 1. Secondly, Lordship, in 489, 589.
That is not an issue here.
589, which is filed and pending before subjudice, which my learned friend has issued. All these issues has been raised, and it is subjudice. That is why, Lordship, yesterday I was making a submission that since all these issues has been re-agitated in 589, and it is pending before the trial court. As on today, IA 589, this honorable court should not interfere or should not traverse into these issues, because that will amount to constructive res judicata, or it will be or knowingly, unknowingly, it will influence the decision of the learned trial court, because in Civil Revision 19, this honorable court has given them liberty that to raise preliminary issues. Lordship, the word is preliminary issues. And accordingly, Lordship, and without to be, and any issue to be decided by the appropriate court should not, the earlier judgment in 455 should not work as a res judicata. That was, your Lordship. And in view of the fact that it is an interlocutory application. So, Lordship, since morning, my learned friend, I have listened to 2 hours, 15 minutes. I did not utter a word. Lordship must have, I was patiently listening. So, on those, all along, my learned friend was raising the issue on jurisdiction, maintainability, and all those issues, for which she had already, as directed by this honorable court in Civil Revision 19, giving her liberty to raise preliminary issues. Instead of filing a WS, she has filed 589, it is subjudiced. So, Lordship, and Lordship, this is a revision petition. And the revision petition is only on one ground, that maintainability was not considered by the learned trial court before issuing the temporary injunction. That is the only one ground on which, Lordship, the temporary injunction was vacated by the learned appellate court, and that is the only question on review before this honorable court. That is why the other day I was also mentioning, Lordship, that this is a review under 150 in read with 151. So Lordship, whether we can, it is not an appeal. It is not a first appeal. So Lordship, whether we can enlarge in a civil revision petition and go and look onto those issues which is not been dealt with by the learned appellate court in, well, vacating 388. Because 388 was vacated only on one ground, that Lordship, that the question of maintainability was not considered. And Lordship, it was also clearly mentioned in that judgment, in the last paragraph, that in view of the fact that maintainability goes to the root of the case, root of the matter, it is not necessary for appellate court to look into the other issues. And I was also making a submission that the learned court must have been aware, appellate court must have been aware that by the time the matter was heard on 20th of January, December, IA 589 was already filed on 12th of December 2024 on those issues, on the same issues which has been repeated all over again today. So Lordship, my respectful submission to go all those issues under revision will be beyond the jurisdiction of this honorable court under 150. That is why, Lordship, yesterday in my submission, I had only confined to the issue of maintainability. I did not traverse beyond that because that was the only point of revision, because that is only one point. So, my Lordship, since it is not an appeal, it is not the first appeal under Order 43, but it is only a review petition under 150. Under 115, read with 151, Lordship, with due respect, should be conscious about the jurisdiction of this honorable court in the revision petition. In my respectful submission, this honorable court cannot traverse beyond. Otherwise, there will be, my lord, exercise of jurisdiction beyond the power of revision. Now, my lord, yesterday, now coming to the point, specific points queries, I will not repeat what I have submitted yesterday.
But you have limited time.
Yes.
Only 5 minutes.
My lord, I'm only replying to the points I have noted down.
You have noted so much.
No, I will only one few points of what, my lord, it is by, at least I will not explain. But my lord, since new issues have been raised by him, I think it is my entitlement to make pointed reply. I will not make long explanation, just one pointed replies.
Yes.
Yesterday,
You can submit written gist of your argument.
I will do that. What, my lord, kindly allow me to conclude in short, a few important points so that your lordship.
But
because,
I can't grant you unlimited time.
My lord, I will not. I'll take, if your lordship prescribe the time, I'll confine to that.
5 minutes.
Lordship. One, yesterday, lordship has raised 3 queries. My lord, if IA 589 is rejected by the appellate court below, then since the written statement is not filed, what happens? One, under what provision of law?
That is not the subject matter of this revision.
I'm only asking.
Though I raised.
Yes. Secondly, lordship, under what provision of law, IA to be filed to raise preliminary issues on maintainability when written statement is not filed? That was the second question you asked. Lordship, I'm sorry, lordship, not you, lordship. I withdraw my word. That is not the right. Thirdly, lordship, it asked that the defendant to satisfy that in both 388/2024 and 455/24 by the order dated 18/11/2024 by the trial court, the issue of maintainability has been simultaneously dealt with. So, the reason why this honorable court should not interfere with the judgment of the appellate court when maintainability issue has been adequately addressed in both 388 and 455. That is one. Then, lordship, my learned friend has raised an issue about tribal court, that it is a tribal court under chapter 2. My lord, since there is no time, my lord, that chapter 2 of the Nagaland Village Council Act was deleted by Second Amendment Act of 1990. So the chapter 2 is no more in the act. However, my lord, in the 4th amendment, my lord, the tribal council was brought back. with a direction for the tribal council to assess law and order and other issues. Accordingly, in the constitution of the Sumi Ho Ho, it is clearly mentioned that it is not the statutory party. And since I don't have time, Lordship, I'm not going to.
One query.
Yes,
I will extend time. While exercising revisional jurisdiction
Lordship.
against an order where injunction was granted or vacated.
Yes,
In this case, the first appellate court did not deal with the other issues like
Yes.
prima facie case and
Yes.
irreparable damage.
yes,
It only restricted itself to the question of maintainability.
yes.
Now, while exercising the revisional jurisdiction, can this court go into
My,
question whether
in my,
there was prima facie case, there was irreparable
My lord,
damage?
my lord, in the normal circumstances, issue would have been different. But in this present case, this honorable court has passed an order in Civil Revision 19, giving a direction to him, to the respondents, to avail the opportunity of approaching the original trial court objection in accordance with law.
No.
Thereafter, Lordship, I'm coming to that. Thereafter, on 12/12/2024, IAF 589 was filed, raising the same issue before the learned trial court.
Regarding maintainability,
Regarding maintainability and all those issues on subsequent repetition on the issue of jurisdiction, on the issue of local standing.
that was not my query.
Lordship.
My query was while granting temporary injunction, three considerations like irreparable
Yes.
injury,
Yes,
balance of convenience,
yes,
and prima facie case
yes,
has to be considered
Yes.
by the trial court. But the first appellate court vacated the trial court order after discussing only the question of maintainability.
in my respectful submission.
Can this court go into the issues?
No, my lord, in my respectful submission, because Lordship, because it is revisional jurisdiction. So revisional jurisdiction, Lordship, may kindly read again, so to save time, I'm not reading, Lordship, kindly read 115 again. Because the power of revision is very limited under 150, that it cannot go beyond the judgments under revision. It is not a first appeal, it is not a first appeal, Lordship. So we cannot reassess the evidence. It is only to examine the legality of the order passed. Nothing more, nothing less. That is why I have been repeatedly submitting from the other day that
Okay,
115 is
your
very
time
limited.
is over.
Yes,
If you have anything to submit,
Lordship.
any major point,
My lord,
you replied in writing.
Lordship,
You can also give gist of your argument
my lord,
tomorrow.
my lord, my lord, let it be on Thursday.
Okay,
Let it
Thursday,
be Thursday. Let it be on
day
Thursday.
after tomorrow.
Yeah, because
Oh, okay.
for writing,
I'll reserve the judgment.
Lordship,
Lordship.
on Thursday.
Both of you are requested to give written gist of your submission.
So, my lord, in a separate column, I will give my reply to her submission.
Yes.
In the
yes,
submission, so that,
yes. The points which you want to bring to the notice.
yes, yes, my lord, only the pointed replies.
Okay, heard. Mr. Takamasha, learned senior counsel, assisted by Mr.
Arendo.
Aren Law, learned counsel for the petitioner. Also heard Miss Z. Zimomi, learned counsel for the respondents. Hearing the petitioner, learned counsel for both the sides are requested to give written gist of their submissions to the courtmaster
Yes,
on
20.
by day after tomorrow,
Yes, that should be 20, 20.
20.
Lordship.
The hearing concluded, judgment reserved.
Much obliged, Lordship.
Highly obliged, Lordship.
Saya without. That is the fun part. You are performing your duty calls, nothing personal, nothing personal. When they came, I told them also, it is nothing personal, we are performing our duty, so I have seen the whatever, it's a social media report also, so I told them that it should not be personalized, because I have told them, because we are performing our duty, so that is nothing personal, so our professional and personal relationship will be different.
At least in my name, they could